morning, everybody. The time is 9:01 a.m., and I hereby call this Citrus County Code Compliance hearing to order. At these hearings, we have an agenda, and the first item on the agenda is the call to order. Handled that. The second is the pledge to the flag, so I'd like to ask if you join me in standing for the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning. If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
The next item on the agenda is approving the minutes from the July 20th, 2022 hearing. I've reviewed the minutes. Does anyone have any objections to them as currently formulated or modifications to them? Hearing and seeing none, I will go ahead and approve the minutes.
Staff update: abated and continued cases are posted out front.
Okay. Good morning again, everyone. I want to introduce myself. My name is Christian Waugh, and I'm a licensed Florida attorney in this capacity as what's called a special master. That's a fancy title created by law, but all it means is that Citrus County has hired me to preside over your hearing today. When your case is called, please come forward, and you will be placed under oath. If you are appearing at a hearing like this for the first time, I'll state the alleged violation against you and allow the county to present its case first. You will then have an opportunity to present your case in response to the county's case, and that may include evidence if you wish. During this process, the county attorney's office or myself may have questions of the parties, witnesses, or staff. I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and be made as succinctly as possible. This is not an appropriate forum for personal attacks, and I will remind everyone that these hearings are videotaped and published on YouTube. In most instances, if you are found guilty of a violation, the law requires that you be given time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law then allows Citrus County to impose that fine as a lien on all property that you own, and the county may foreclose on such lien or seek money judgment against you after that lien has been recorded for 3 months. This is important because I may not give you another date to appear before me, and therefore you likely will not have another opportunity to plead your case or to explain why you didn't comply with the county code. In all cases in which I find someone guilty of a violation, I will impose all costs that are required by the county laws. If you abate or fix the violation in the time granted, that cost will remain minimal. If you do not timely fix the violation, you'll be responsible for those additional costs. If I find you guilty of a violation and allow for a continuance of your case, you'll be required to return on a certain date. In the time between the hearings, I'll require that you comply with the county and its laws in order to consider the violation resolved. If your violation is not resolved by that next date, I may impose a fine for each day of the violation from today's date forward. Your failure to return on the next date may be deemed evidence of your failure to cooperate with the county. Do we have any appeals of orders to demolish? Okay.
No.
Ladies and gentlemen, you do have the right to appeal any order that I make today as provided by law. Thank you.
First case on the agenda, Joseph Darmiento, case numbers 216-5142 and 216-5144, pages 10 and 11 on your agenda. Code officer on the case, Matt Hampton. Expert on the case, Land Development Director Joanna Katu.
Good morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Please state your name for the record, sir.
Joseph Darmiento.
Thank you.
Good morning.
Good morning.
Being that these are two LDC violations, I'm going to run them separately.
Okay.
Okay. First one will be 216-5142. 4002 site development without a development order or permit, violation of Citrus County Land Development Code. The address is 6261 West Homosassa Trail, Homosassa, Florida. Property owner is Darmiento Joseph. Good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents requested to be admitted into evidence. Exhibit A is photos I took during my initial inspection, May 25th, 2022. Photos I took during my corrective action inspection, July 25th, 2022. And photos I took during my final inspection, August 16th, 2022. Exhibit B will be a copy of the property appraiser showing the property is a vacant parcel, a copy of the notice of violation, a copy of the notice of hearing, and a picture of the notice of hearing posted at the property, and a copy of the posting affidavit I completed on August 4th, 2022. And Exhibit C will be 2 different aerial pictures taken from Citrus County Property Appraiser's website to show the tree density on the property.
Sir, what I'd like to ask you to do is to look at the documents that he's just described and that he's going to give you, and let me know if you have any objection to them being evidence in this hearing.
What would be a good objection?
That's for you to determine, or for your lawyer if you have one to determine. But basically, the way it works is that if you have an objection or a concern as to its authenticity, if you think the photo wasn't actually taken by him or it doesn't actually depict the property, that would be a concerning objection for me. If you just want to talk about the photos, though, that's just going to be your right. It's not really an objection to the evidence, and if that makes sense.
Well, I'm not going to object the photos, but I would like to say something about this.
And you will have that right. So before I can even really hear commentary about them, they need to be introduced as evidence. So I just want you to take your time and look through them right now, and let me know if you have any objection. And by the way, you may have an objection I haven't described, and if you do, I'm happy to take it up with you. Don't feel pressured to have a right objection.
Well,
or
I'm not a lawyer or
objection.
nothing, so I really don't.
You really don't have to be.
Objection.
Lawyers are overrated.
All I can say is that, yeah, this is my stuff and my property and my junk, but this all started from my house, and I've been getting, like, for 2 years now, they've been trying to, it started from my house. I bought another piece of property. I moved the trucks for the problem that they said it was. They came at me with another problem, said, oh, this is the reason. You can't have a tow truck on a residential property. 3 other houses in my neighborhood have tow trucks on residential property if they own them. I own the truck. They're tagged. They're titled. So then I bought another piece of property next to a tow yard, which is this property.
Well, Mr. Darmiento, I want you to be able to make your case, but what I need to know is if you have objections to the photos at this
No,
point.
I don't. These are good photos.
Okay. Well, I think there's one exhibit that's not just photos, so if you can, just take a look at them and let me know if you have an objection.
I don't think I do, boss.
Okay. All right. So I appreciate your patience. The way this normally works on the hearings is that the photos are then, the proposed exhibits are presented to the assistant county attorney, and we'll make sure that the county doesn't have any concerns before they become evidence. All right, then without objection, what's been proposed as exhibits A, B, and C are evidence, and I'll allow the county to present its case.
I conducted my initial inspection on May 25th, 2022. I observed the property to be in violation of the Land Development Code listed above. There was a large amount of trees removed from a vacant lot. I conducted my corrective action inspection on July 25th, 2022. Notice a hearing was issued July 25th, 2022. I have had contact with property owner, Mr. Darmiento, and he was not happy about the violation. He asked how he was supposed to make a living if he cannot do what he wants on his own property. As of my final inspection on August 16th, 2022, it does not appear if any more trees were removed.
Is this the LDC as amended?
No, it's it's the previous, and the reason it's the previous is because it was witnessed before the new one was made effective. The effective date was July 14th. This was done on May 25th.
Yeah.
And I didn't go and issue the notice of violation after the fact because he wanted to get it to hearing.
I agree with you. I think I'll only note that for the agenda, it looks like it's the amended code section that's in the agenda. I don't know if that's right. No?
I don't think so. No.
I would just check on it. But, all right, so is there anyone else from the county who wishes to testify?
Joanna Coutu, Land Development Director. That is a low-density residential designated property. It should be vacant. We don't have any permits for it. I can say he did come into the office on August 4th to pick up a land use change application. We did tell him it's somewhat unlikely. He's surrounded on all four sides by residential land.
What's the proposed change?
I don't know. He
Okay.
had to apply. It was just an application handed to him, but I'm assuming it's some kind of commercial zoning to try to allow this.
So to be clear, under this code section, it's the county's case that no development, i.e. removing or cutting down of trees, can be done until there's a site plan approved?
A house permit issued, yes.
Okay, all right. I think I'm familiar with this code section. And so, Mr. Darmiento, we're only talking about this case. There's two cases that are being presented. Is what the county's saying, does that make sense to you?
That I can't put my stuff there because it's supposed to be a house built there.
I don't think specifically what they're saying is that you can't have your stuff there. I think what they're saying for this case is that you've basically removed some trees before getting a permit to build on the
Yeah, I
property.
didn't know that you couldn't cut your own trees down.
Well, most people don't know that, but look at, this is how big the code section is that governs your property and development. So there's a lot in there, and I mean, you've heard the county's case. Do you have any? Do you think you're not guilty of it, or?
I mean, I guess I'm.
Did he remove the
guilty.
trees?
Yeah, I mean,
Yeah.
if the book says I'm guilty of cutting the trees down.
The photos look like you got rid of some trees.
Yeah, I did. I'm not gonna lie to you.
all
I
right,
cut a couple
yeah.
of trees down and put my junk there.
Well, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violation and the respondent's action relative to this violation. We would also ask the special master additionally find it as a respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
What does he have to do in order to abate it? Pull a permit?
He would have to pull a permit for development on the property.
Is that the only
correct?
thing? Is that the only way that he can abate this?
Yeah, if he had a permit that actually told how many trees he's removed and how many need to stay, that kind of thing. We're in the old code right now, so,
Yeah.
yeah, and I looked, and that is the old code that's
It is
that's
okay. I
referenced.
just wanted to make sure.
Yeah, yeah.
Um,
Once you see the stuff about multifamily development in there, it's old.
well, see, I'm looking at 402, and in the agenda, there's a one. It's just different than the 40. I see.
Yeah,
I see.
you got
This
the
is
new
the
one.
amended.
Yeah.
Okay, I
That's
got
the
you.
new one,
Okay. All right. Mr. Darmiento, do you intend to build on this property?
Well, I talked to the people, like they said in this office, and they gave me a packet of paper. They said, because there is other tow yards all down this road. There's 3 or 4 of them on the same road. And I asked him, is it possible that I could make my color red, because that's the color that you got to be to get commercial? Well, he said if he gave me the paperwork to do all that, and he said you got to do this, but he recommended me to do industrial, but I didn't want to ruffle no feathers because there's no other industrial on that road. So I didn't want to be completely told, no, you can't do that. So I wanted to come here and see, would I be able to make it red if I did the right paperwork?
Unfortunately, that's not something I know. I don't represent the county on that. Does the county have a position?
We're morphing into the second case, so if you want to open that up, that's kind of what he's talking about
The reason
here.
why I'd like to do these at the same time is because the penalty in one case may inform the penalty in another case
Yeah,
if
he's
there is a
definitely
penalty.
talking about the second case right now, some of his comments, so.
Well, if he did do the change, would that get rid of the violation here?
No, well, if you got a
Because
permit.
he's not going to do a building permit for a house if he changes it
Right,
to industrial.
Right, he'd have to change the zoning, and then we could go back and look and make sure he has enough trees remaining, see how many he's lost, then he would, yes. So he.
Yes, it would abate the violation in
It
the
would
first
abate the
case?
violation eventually, yes.
Okay. Mr. Hampton, would you mind presenting the second case at the same time?
Not at all, sir.
Thank you.
Now, in the essence of expediency, I can tell you, I'll go through the top, but everything else is like the same, and with the testimony and stuff like that,
Right.
if it saves us time,
It
I'll
does.
just go over the top.
I would appreciate that.
All right, case number 216-5144-3102A, special requirements for all accessory use structures, a violation of Citrus County Land Development Code 3102A. Address 6261 West Homosassa Trail, Homosassa, Florida. Property owner, Darmiento Joseph. I go good service posting of the property in the Lecanto Government Building. The exhibits are, with the exception, this one does not have Exhibit C. It just has the first two photos took during exhibit.
Right.
You want me to go over that, or?
No, if A and B are substantially similar or
They
the
are.
same,
They are.
Okay.
With the exception of, I don't have Exhibit C on this one.
that's fine. Then
Okay.
we can get that out of the way. Mr. Darmiento, do you understand what he just said? Basically, exhibits A and B are going to be the same as in the previous case. You didn't have any objection to those. I'm hoping you don't have any objection to these.
What, the pictures again? The tree?
Correct. It's the same thing you just looked at.
No, this is my property, and I cut a few trees down. I did.
Okay. This is the second case, so there's two different violations here. What I'm trying to do is have them both addressed at the same time, because whatever the way to fix this is might be linked together.
Yes, sir.
All right, so seeing as there's no objection to these exhibits, we'll introduce them as exhibits A and B in case number 216-5144. Okay. Thank you. And so, what's the issue for this violation?
The issue for this violation is the fact that he brought on all those vehicles, he's got the trucks, the RVs and whatnot, and it is a vacant parcel, so, obviously, you can't store things and keep things on a vacant parcel.
So there's an accessory use, storage, keeping stuff there.
Yes, sir.
And that's not proper without, I assume, some kind of principal use, given that this is a residential.
Right, you're correct. I'm not exactly sure what these are being used for, but if he had a house there and he has his own work trucks parked there, that would all be allowed with a house permit.
I see.
If there's a business operation, it gets a little different, but.
Okay.
Can I say something?
Yeah, of course.
Okay, I had my tow trucks first at my residential property. She just said if I had a house there, I'd be able to have my work trucks there. Well, he came and told me I can't have my work trucks at this house, even though they're tagged and registered. I have to find somewhere else for them to be. So,
Well, that's, honestly, I can't talk about
that's how
another
this
case.
And it started from there. I moved my trucks. I bought another piece of property. He came there and said, "Oh, you can't have them at this house." So, am I allowed to have my tow truck?
I should have clarified, a larger truck, depending on the weight, like if it's a big tow truck, no, you cannot. When I said work trucks, I meant like the small box trucks and things, or pickup trucks. Truck parking is not normally allowed, but you can permit it there with a commercial lot. There's limits on where commercial
Are
can
we
be
talking
in
about
residential.
trucks 10,000 pounds or more?
We are, yes, your favorite part of the code.
It is.
Yeah.
It's my number one
Right.
favorite
so,
code section.
So if right. So not all trucks can be allowed at residential. When I say work trucks, I'm kind of thinking people bring home their pickup
So
trucks.
I don't want to get confused with these issues. The only issue is, look, this is a vacant, it's supposed to be a vacant piece of land. So what they're saying is, until you get the principal use on the land, I don't know what happened with your other place or anything. All I know is what's happening here is you're not allowed to really use this vacant piece of land for anything unless and until you get the principal use going, which, because it's zoned residential, you've got to get a building permit for a house, basically, if that makes sense.
Well, I was in the process of I'll either put a house there, but I would like to get it zoned red. And the guy told me it would take at least 6 to 8 months if they allow it.
Right.
Understand? But if I get the right paperwork, are y'all going to allow it, or am I just waiting?
They cannot promise that to you, so there's a little bit of risk here. What happens sometimes is I talk to the county about it, I talk to you, and I try to give enough time for you to do what you need to do to fix the situation. Now, in the event that I give you enough time to rezone or change the land use, whatever it is, both probably, and it doesn't work out, it would be important to try and find that out as soon as possible, because the only other way you'll be able to, well, frankly, what the county's saying is that there's no way to abate it except for pulling a building permit, despite the fact that, let's see what this code section says. A site development plan shall be required for any multifamily residential development and why were you cutting the trees down?
so I can store my stuff there? Or
Okay. A site development plan shall be required for any multifamily residential development and non-residential development. The following are exempt from this requirement: agricultural, single-family dwellings, lots in in recognized unrecorded subdivisions, duplex residential structures, or lots in recognized unrecorded subdivisions, accessory structures, and other uses that do not require extensive review by county staff and can be approved through the building permit process. Because you're doing storage, you're basically just proposing to use it as storage. It doesn't seem as though it would even need the building permit process, so it probably doesn't fit that exception. Does the county agree with that?
No, you would still need a site improvement plan, a site development plan for the storage use.
Well, what I'm saying is there's not a building permit process for that, right?
It is the building permit process, is a site development plan that's
Okay.
that goes through the building permit process.
I see. All right.
It's not the building code.
I see. All right. And is it the county's position that what he's doing with the property would require extensive review by county staff?
I'm not entirely sure what he's doing, but the tree removal and storage on a vacant lot without a primary, yes.
Why would that require extensive review?
We would be looking at the number of trees there. We'd be looking at storage. We're looking at access aisles. Are they improved, impervious surface, stormwater?
Wouldn't you be looking at that for all the other exceptions in this code section, such as single-family dwellings on lawfully platted or recorded lots, or duplex residential structures?
Exactly why we changed that code, because of this argument, yes. The other case.
What I'm
probably
going to
simpler.
do is I want to ask the county's recommendation on the second case.
Recommendation is the same as the
Okay.
first one with the $50. Do you want me to read all of it again?
No, I appreciate that.
Okay.
Mr. Darmiento, here's what I'm inclined to do. I don't think this will come as a shock to some people in this room, but I have a concern that this case, that the first case presented actually fits an exception in the code, in the old version of the code. I believe it does. I believe that they've changed the code, however. Okay, so what that means is the county could probably re-inspect the property under the new code section, issue another notice of violation for this same section, and it won't have the result that it's about to have. Okay, I'm going to dismiss or find in your favor, Mr. Darmiento, on case number 2165142, because I do think it fits the exception in subsection B. I do not think if the county presents another case on this code section under the new version that you'll be able to escape it, okay? But that said, I am going to find that there's a violation on the second case, which is this accessory use. It's storage in a vacant lot. You've got to get something built there. What I'm going to do is, it doesn't look like there's any immediate threat to public welfare or health. I'll give you 8 months, okay, to try and rezone and fix this. But if you are unsuccessful, the only other way to abate it is to get everything off that property.
Yes, sir. This is what I understand what you're telling me. You give me 8 months. If I can't get it rezoned, I have to build something there. Then I would be able to keep my junk there with the fence around it. Would that be?
It depends on what you succeed in rezoning it to. I can't represent that.
All right.
Okay. What I'm giving you is 8 months to abate the violations.
Do I come back here after the 8 months and talk to you again, or do I?
That won't happen.
Alright.
So either it's going to be fixed and the case goes away, or there's a violation and the county presents an affidavit of a violation to me.
They tell me again that what's wrong.
The county's going to work with you, assuming you're working with them.
Yes, sir.
But I can't force anybody to do anything. Okay.
I'm just saying they're going to tell me after the 8 months is up. Look, your 8 months is up. Either you fix it or you didn't. They'll tell.
I think you need to be in touch with them,
Alright.
okay, on a regular basis
Yes,
about
sir.
the status of your application.
All right.
I think that'll make a big difference to the county.
All right.
But
Thank you.
I can't control them.
I really appreciate all the help.
Okay, so here's what I'm going to do. In case number 216-5144, I am going to find that the property is in violation, and I will grant 8 months, not a specific number of days, from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of you, Mr. Darmiento. The county attorney's office may sue foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Yes, sir.
Okay.
Thank you. I'll take care of it.
All right, good luck.
Second case on the agenda, Clear Card Holder LLC, case number 216-4933, Code Officer Alan Jonason. Oh, page 9 of your agenda.
All right.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning.
Sir,
Alan
did
Jo-
you say I do? I didn't. Okay.
Oh, he did.
All right, I just didn't hear.
Alan
Good
Jonason, Citrus County Code Compliance Officer. This is a continuation of case number 216-4933, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A.
I remember, and I'll reincorporate the evidentiary record from that hearing.
Outstanding. The address is 4535 North Remington Terrace, Hernando, Florida. Property owner is Clear Card Holder LLC. I have good service via signed certified mail return receipt and posting at the Lecanto government building.
We already know that. This is just a continued hearing. This was the case of the laser defense.
Yes.
So what have you guys been able to determine?
So I have a GIS printout from the GIS section showing the property line.
Okay.
I also have a elevation diagram showing the elevation of the pit, if that is required.
Is that Google Maps?
No. This
Okay.
is off of the property appraiser and the GIS
Okay.
system. I will. If
Have
you
these
like-
been shown? And sir, what's your name?
Ian Jobert.
Jobert, Mr. Jobert.
Some of these are new.
Okay.
Because we needed to.
Yeah, and I just want to make sure he can see them.
Yeah, these-
Mr. Jobert, have you had a chance to look at the line, or has your position on this changed at all since the last hearing?
My position has not changed.
Okay. So I guess what I'm asking is if you can look through these documents and let me know if you have any objection to them being used.
Yes. I do object to them being used. As he said, he went through the property appraiser's website and got them off the GIS. And I have a printout of the opening page of the property appraiser's website that indicates that nothing in there can be used as legal advice. It is there for informational purposes only.
And so what they mean by that is, you take your own risk when you rely on it. In other words, they're disclaiming any liability for your reliance on those documents, kind of like a buyer beware thing. But that's a comment as to the quality of the evidence, not a comment as to whether it's actually accurate or not. So, do you have any reason that these should not be evidence in the hearing? Besides
No.
that,
No,
I
I
think
don't.
that's,
Thank you. Yep.
all right. Is there anyone here from the public who's going to want to speak on this case? Okay. Let the record reflect that there was no response.
Okay, so which exhibits are from RGIS? Okay.
This is the GIS that shows the property boundaries.
Just to be clear, the only record that's from the property appraiser's office was exhibit A, number 12 of 14, and 13 of 14, but the GIS map, 14 of 14 is from the county, that's a county record.
Well, either way, I'll need the county to explain what these documents mean. All right, so I'm overruling the objection, admitting these as evidence over objection as exhibits. Are these the, is this, okay, so this is, what portion of this Exhibit A was admitted before?
The ones that have holes punched in them, sir.
The holes punched in
Yes,
them?
sir. The ones that are,
I don't see any hole. Oh, I
right,
see,
yes,
I
sir.
see, all right,
Those are from the original case file.
all right.
And those dates on those are from 24 May and 23 June, and then 16 August yesterday was my last inspection.
All right, then let's make this clear. Pages 1 through 7 of Exhibit A are probably already in the record. I'm being represented, it's being represented to me that they're already in the record. Pages 8 through 14 are new, and that is the portion that is now being admitted over objection. So I'm just going to take a moment and look and see if I can make heads or tails of this, and then I'll ask the county to explain. Okay. I think I do understand the point behind the property appraiser site. All right, Mr. Jonathan, what do you have to say?
Again, according to the GIS website, the property line, the pit is actually within that property line, and the violation is within the address 4535 North Remington.
Mr. Joubert, at the last hearing, you'd indicated that you did some kind of a, I guess I'll call it a sophisticated measurement. I don't know how to measure that way. And suggested that while you weren't 100% sure, and I don't want to put words in your mouth, but let me know if this is accurate, that while you weren't entirely sure, it looked to you like this was not in your property where all the junk was, or at least most of the junk. Is that accurate?
That's accurate, yes.
Okay. I mean, I know you've objected to the property appraiser documents. It's not something to be relied on, and as a board certified real estate attorney, I can tell you I usually don't, because it may be that they get the legal description wrong. It's not their job to review and determine who the actual owner of something is. But for this kind of purpose, usually what they do is they just create an outline based on the recorded legal description. It looks like it matches what your LLC is the owner of. So I'm wondering what basis there is to not determine that there's an accumulation of junk and debris on this property.
Well, I would go back to just the evidence presented and the quality of that evidence. I do have some printouts here.
Okay.
If I can.
Well, why don't you show them to the county? You want to introduce this as evidence?
Please.
Okay. Does the county have any objection as to what is being handed to it being evidence in this hearing? So I think the front page is that disclaimer on the property appraiser, which I'm going to admit as relevant for the quality of the property appraiser documents.
And these are printouts from the property appraiser website.
So you also have printouts from the property appraiser website?
Yes.
Okay.
I have no objection.
Okay.
I don't know really what they're depicting.
I don't either. So let me look, and they look okay. Then I'll admit them as respondents A. And Mr. Joubert, please feel free to tell me what I'm looking at.
Okay, these pictures, I apologize for the quality of the printout, but they show the property line on the property appraiser's website is going down through the shadowed area, which is down through the pit. The shadowed area is the pit, and you can see the property line is going down through there. Unfortunately, the one that showed up just as an outline is a view from the pictometry on the website, and it shows the property line halfway through the other fellow's property. It cuts through his shed. 2/3 of the shed is shown as being on our property in that particular picture. So there is no consistency whatsoever to any of the information on the property appraiser's website.
All right, let me take a moment and look at this.
And I would like to add some information when you're ready.
Okay, go ahead.
I had been out there this past Saturday, had somebody with me, tied a rope to me to try and scale down the side of the pit. Got to some of the garbage, but not all of it, just could not get down there. Went through several of the bags and sifted through some of the stuff. I was unable to find any mail in there. Somebody had done a reasonable job of probably burning all the burnables, and there were cans and metal bagged up in some bags and, you know, loose debris in other bags. I called the sheriff's department and they were unwilling to even come out. They just said there's nothing we can do about it, put up some trail cameras. So I have been trying to move forward to be helpful with this.
Yeah, I mean, so here's where I'm coming down. I'm looking at the photos. They look, you said they're not consistent. They look very consistent to me. The outline, the parts that they go over. I'm looking at a partial tree, I do take your point that it appears the property outline does not fully cover the pit. But I'm looking at the photos that show the trash is strewn across all of the pit, essentially. So it does appear to me that there's a violation. Now, the point about the difficulty of scaling, that frankly, the fact that it seems people are just using it as their own dump and common area, if you will, goes toward how long it'll take to fix. And so, assuming I do find a violation, how long will it take you to clean your part of the pit up?
It's a very good question. I am unsure of what sort of permitting process I will need to go through to clean this up. As I indicated last time I was in here, I think I'd need to bring in fill dirt and equipment to build a road to get down in there to do this. I'm not sure if there are any DEP issues going on with, putting fill down in a hole like that, whether I'd have to put it down in there to build the road and then remove it afterwards. The edge of this pit is just far too steep to get any sort of equipment on it. Can't get a lawnmower down there. The vines are too thick for weed eaters to try and make any sort of even footpath. I simply don't even know how to go about doing it at this point. The garbage is slid far enough down the side of there that there's no using a track hoe or excavator. Even a long stick one would not reach down far enough. The access would be from the neighbor's property, and from a couple of brief conversations I've had with the neighbors, there's not going to be any cooperation from them. I would not be able to
Is it landlocked?
No, but all the garbage came from their property and is sliding down the hill that borders that neighbor's house. And their yard is fenced in, so that was not just random people in the neighborhood, it was them.
I mean, it does look like it's pretty steep. So I take the point that it may take some time.
Yes.
So you're just saying you can't give me an estimated time. I'm doing this for your benefit.
Yes, I understand that. And depending on, if I need to go through any permitting process, basically I'd be doing site work just to get down in there. And they're discussing, the last gentleman and taking out some trees was considered site work, and it was supposed to be permitted. So I am not even sure what the process would be at this point. 9 months.
Okay. The issue is, this is the kind of property that, because of, I mean, it just doesn't look good. There's a lot of junk there that could actually arise to an issue where there's pests and other things, and this is something that is a concern for public health. I think 9 months is a bit much. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay. Let's see. All right. What I'm going to do is I'll find that the property is in violation, but I will grant 120 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constantly on the real personal property of Clear Cardholder LLC. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and Clear Cardholder LLC will be responsible to pay all costs required by county law, which would also be incorporated into the lien. Good luck.
Thank you.
Next case on the agenda, Belinda S. Bishop, case number 216-2402, Code Officer Jillian Nocella, page 8 of your agenda. Expert on the case, Carl Jones, Building Director.
I'm sorry, what page of the agenda?
Page 8.
Thank you.
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Jillian Nocella, Citrus County Code Compliance Officer. This is case number 216-2402, Chapter 18, Article 1, Section 18-8A, obtained after the fact permit for all construction or modifications of the Citrus County Code of Ordinances. Address is 6630 South Merling Loop, Floral City, Florida, 34436. Property owner is Belinda S. Bishop. Good service via posting at the property in the Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on April 13th, 2022. Photos taken at my final inspection yesterday, August 16th, 2022. It's also a screenshot of the property appraiser's photo of the home back in 2010 to show the change, and a screenshot of the permit history in Hanson. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, and photos of the posted property, and copy of the posting affidavit.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response. Without objection, what's been proposed as Exhibits A and B are evidence. Please proceed.
On April 12th, 2022, information was received from the building department, and a case was opened regarding a carport that was enclosed into a garage, and the work was done without a permit. Research was conducted in Hanson. It was verified that a permit to complete the work had not been applied for or issued. On April 13th, 2022, an inspection was conducted at the property. During that inspection, it was observed that the carport had been closed into a garage. And as of my final inspection yesterday, August 16th, 2022, there have been no changes. And as of this morning, no permits have been issued for the work done.
Is there anyone else from the county who wishes to testify?
Carl Jones, Building Division Director. The only thing I have to add is that I've looked at the photographs and the evidence, and I can testify that a permit will be required for that type of work to happen.
Okay.
And during the Cotulla Land Development, I have spoken with Clark Stillwell, attorney, who says he represents the bishops to me as recently as yesterday, but also periodically over the past few weeks. He is aware of how to resolve the permitting process. They had to deal with setbacks. We've got that straightened out. He has to do a maintenance easement agreement on the side lot line. He's working on that.
Why?
It's too close to the side lot line. It's a 0 setback. And you need to be 5 on the right side when you're looking from the road. at least on the plans.
The only reason why I'm surprised is because it looks like, I mean, isn't another part of the house already in that setback?
Not on the site plan he's provided.
Really? Okay.
Right, on the site plan, it's closer than the house, a few feet, less than 5.
Okay.
So he can, he's doing that, he's worked on
Oh,
that.
I see
so,
it. I
yeah.
see it. Yeah.
So he needs to do that, and flood review needed a construction cost estimate. I know they are working, and like I said, as recently as yesterday, we were speaking about this.
Did you guys think they were going to appear at this hearing?
I had no idea whether
I
they
mean,
were
did
going
they-
to or not.
okay.
He didn't represent that to me.
Okay. Did they ask for a specific amount of time to fix this?
I've not spoken with anyone.
Okay. It doesn't look like the worst unpermitted job, but I don't know. That's why it requires the expertise of the county to go and inspect. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation. The property owner is granted 60 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Ms. Bishop. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law. Thank you.
Thank you.
Next case on the agenda, Troy and Christina Izguardo. Case number 2166452. Code officer on the case, Amy Becker. Experts on the case, Carl Jones and Joanna Coutu. Page 20 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please
do.
state your name for the record?
Troy Izquierdo.
Thank you.
And ma'am, can you also state your name for the record?
Christina Izquierdo.
Thank you.
Good morning.
Good morning.
Amy Becker, Code Compliance Officer. This is case number 2166452, referred to the Code Compliance Division from licensing after the fact permit violation of the Citrus County Code of Ordinances, Chapter 18, Article 1, Section 18-8A. The address is 3065 West Cypress Drive, Denoan, Florida. The property owner is Izquierdo and Kathleen Izquierdo. Christina. So I apologize. I have good service via posting of the property as well as the Lecanto Government Complex. I would like to authenticate the following documents and request that they be admitted into evidence. Photos taken during my initial inspection on June 15, 2022. Photos taken on July 1st, 2022 at my corrective action inspection. Photos taken on August 3rd showing the posting of the property. And photos taken on my final inspection, August 16th, 2022.
Ma'am and sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing. And take your time.
Nope, no objections.
Okay. Is there anyone from the public who's going to want to be heard on this case? Let the record reflect that there is no response. Without objection, what's been proposed as, I think, Exhibits A and B are evidence. Before I make you go on, Ms. Becker, I want to ask the Izquierdos first. Do you agree with what the county's saying, or are you going to argue that there is no violation?
No, we absolutely agree.
Okay, so they're already conceding the violation. All right, so for evidentiary purposes, I don't think it's, I mean, unless the county, does the county still want to present its case? I've admitted the evidence, they've conceded the case. At this point, I think it's only necessary to ask for the county's recommendation and ask them how much time they need to fix it.
Well, I'd rather have a full record, just in case.
Please go ahead, Ms.
Sorry.
Becker. I'm not going to deprive the county of its chance.
June 15th, 2022, I observed carport, shed, and steel screen porch at the property. I posted the notice of violation at the property. Upon arrival back to the office, I checked Hanson and did not find permits for the structures, which is a clear violation of the ordinance listed above. And I have not had contact with the property owners, just the tenants.
How long do you need to fix this?
Well, I wish I knew. We've already retained.
If we can
the-
put this into evidence?
Yes.
Sure. Well, yeah, just show it to the county first. And
Thank you.
I assume this has to do with the efforts you've taken already to kind of remediate
Yeah,
this.
it's basically the structural engineering firm that I guess that we're using has such a backlog of situations that we just haven't gotten the engineering back.
Oh, yeah, you and
Now,
everyone else.
I'd like to say just a couple other things, though, just for perspective. So the portable shed, we did purchase on our own. I was ignorant to the fact that I needed a permit. They came out and set it off the fence where they thought was far enough and anchored it for us, etc. When we bought the home 4 years ago, the carport and the screen and porch were just part of the purchase. So we had no idea that nothing had ever been pulled.
Right.
So while waiting on the backlogged engineering firm, I was able to obtain the engineering for the portable shed that we purchased through the manufacturer of the shed. And it's got their, the engineering seal and all that. So if the county would prefer, I can apply for that permit. The reason why I haven't is because I don't do site plans all the time, so I wanted to do one for all three. But for the other two structures that were pre-existing, that's what the letter speaks to, is we are just waiting on them.
And they could not give us a time frame?
I've annoyed them enough to where they won't call me back.
I trust that that's true. Ms. Becker?
Just two things. The first thing is the letter's not signed as far as what they brought, which is,
Emailed it to us.
okay.
It's okay.
that's-
I'm admitting it. By the way, I am admitting this as evidence, respondents say.
And then the only other thing would be that the licensing department, this is going back to 10/5 of 2021.
Okay.
So it's last year.
Yeah.
Did you have anything you wanted to add?
I mean, I take it did the county hear the testimony about the possible steps that they can take to fix this? Is there any concern for how long it will take depending on one method or the other? In other words, one site plan and getting that all in?
I'm gonna give them a site plan.
Okay.
Genesee Land Development, 2015, there was a permit. I had some initial concerns. Looking at this site plan, I don't have any concerns. I hand drew the shed. Please draw it where it really is. But Land Development, no concerns. You're welcome to use it as a starting point.
Okay, great.
That's awesome. It even,
Yeah, 'cause this
it
just
even
looks
shows
like-
future carport on there.
But this still will require, more than a site plan. Yeah, exactly.
His effort, yes.
Right. Mr. Jones, do you have any idea, let's assume that they do everything they need to do in the next couple of weeks just to get the process started, and let's say it gets over to you. How long does it take? How backed up are you guys in terms of?
As far as the building department is concerned, we can expedite any permit in a matter of a week or two to get a permit out. That's not a problem. Where they're gonna run into a problem is finding the engineering. I believe there was an aluminum porch that was done.
Right.
Any aluminum contractor can produce engineering for that porch. So that's one avenue that you may wanna pursue, is find an aluminum contractor, because they can engineer that porch.
So basically, if I understand you, the basic shed
The
dealerships
shed you
that
have engineering for from the manufacturer.
right, but a lot of the same distributors, if you will, where you purchase these, they'll do the aluminum will be an option you can purchase, or the wooden structure you can purchase. Are you saying go to them to try to get?
Any aluminum contractor should be able to look at that porch, run it through their engineering program, and spit
Okay.
out engineering for it.
Aluminum contractor.
The carport is a prefabricated kit that's quite common, and I would almost guess that came from Carports and More.
think
from
it's,
looking at it?
so we bought the home for my grandparents, and
Yeah.
I thought it was a place out on 200.
Okay.
Or 484.
Those buildings are quite common, and engineering for those buildings is also readily available if you'll go to the distributor.
Okay.
So the engineering is available. It may take them a couple of months to get that package put
I
together.
agree. Okay. What I'm prepared to do is to find a violation and grant you, well, I mean, do you have immediate structural concerns or immediate,
Not based on.
is anyone in
not-
imminent danger from these structures?
Not based on the photos that I've seen. There's no imminent to life or safety.
All right, I also agree. So I was going to grant probably 6 months to abate the violation, just because there's more than one. Does the county have any objection to that?
No, that's a reasonable timeframe.
Does that seem reasonable to you?
Yeah.
It does.
Okay,
Absolutely.
I'm going to find the property in violation. You are granted 6 months from today, or actually I'll change that to 180 days from today to abate the violation. If the violation is not brought into compliance as ordered, I'm sorry, what's the county recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the Izquierdos. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owners shall be responsible to pay all costs required by county law. Thank you.
Agree. Thank you.
Next case on the agenda, Denny L. and Claudia D. Flippin, case number 216-2433. Alan Jonason, code officer on the case, page 15 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Gentlemen, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your names?
Dennis Flippin. And Dennis Flippin Jr.
Thank you.
Good morning again. Alan Jonason, Citrus County Code Compliance Officer. This is case number 216-2433. Special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102 Alpha A. The address is 4035 East Bass Lane, Hernando, Florida. Property owner is Flippin Denny L. and Flippin Claudia D. I have good service via signed
Delta.
Delta, yes,
Okay.
sir. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photo taken during an initial inspection on 9 June 2022, photo taken during a compliance inspection on 11 July 2022, and a photo of my final inspection conducted on 16 August 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail receipt.
Sirs, if I could ask you to just take a look at these documents and let me know if you have any objections to them being evidence at this hearing.
Didn't see that one. Yeah. This is the big one. I cleaned all that front up too for you this morning.
Is there anyone from the public who's going to want to be heard on this case? Okay, let the record reflect there is no response. Any objections to the document, sirs? Okay. Without objection, what's been proposed as Exhibits A and B are evidence?
On 9 June 2022, I conducted an initial inspection and observed the property to be in violation. On 9 June 2022, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance listed above. On 11 June 2022, a compliance inspection was conducted with No change to the property. As of my final inspection on 16 August 2022, the property remains in violation.
Have you had contact with the owners?
I have.
Okay. I mean, what's going on?
So the property actually had a lot more than just the shed on it, but they have removed all of that. The shed is the remaining structure on there.
Okay.
They've done a fantastic job cleaning it up.
They've worked with you.
Absolutely. And then I was told that they were working on getting because it's such a large shed, they need some kind of large truck, and they're hard to find or something like that. I'm not for sure.
Is there anyone else from the county who wishes to testify?
Do you want to continue land development? It's CLRMH, Coastal Lakes Residential Mobile Home Allowed, should be vacant. We don't have any permits for it.
So the only ways to abate it would be to remove it or put a principal use and get a permit for the shed.
Correct.
Okay. I'm learning. Does this all make sense to y'all? Are y'all still working on this?
Yes, we're working on it.
Okay. How much time do you need to abate it?
I'm not sure. We've got some people interested in it, and we're going to try to get them to get that out of there as quick as possible. But
You don't know.
don't know exactly what the time period is it's going to be to get it out of there.
Yeah.
It's a large building.
We're trying to get rid of a small jacuzzi in our backyard that we inherited. It's a piece of junk, and I can't get rid of it, so I know. I'm begging people to take it.
What's your address again?
Yeah. Oh, be careful what you wish for. You'll have to take it out of the backyard. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests the special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I'll adopt the county's proposed findings of fact, find the property in violation, grant 120 days from today to abate the violation in light of the fact that so much cooperation has already occurred. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the Flippins. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law.
Thank you.
Thank you.
Thank you.
Yep. Next case on the agenda, Nancy A. Spearing, case number 215-9294, Code Officer J.C. Charlton, page 32 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
Please state your name for the record.
My name is Crystal Sperry. Nancy is my late grandmother.
Okay. Thank you.
Good morning.
Good morning.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 215-9294, a violation of Citrus County Land Development Code Section 3140, temporary uses, Table 3-2. Temporary occupancy of a recreational vehicle is permitted 2 weeks per address per year. The address is 353 North Rock Crusher Road, Crystal River, Florida. Property owner, Nancy A. Spearing. I would like to authenticate the following documents and request to be admitted into evidence. Photos I took during my initial inspection on February 23rd, follow-up inspection on April 12th, corrective action inspection on July 7th, and final inspection on August 16th, all of 2022. Exhibit B, a copy of the notice of violation, notice of hearing, and photos of the posted property, and a copy of the posting affidavit I completed. I also have photos and reports from environmental health. I'd like to add those as Exhibit C.
Ms. Spearing, I'd like to ask you to take a look at these documents, and you've sat through all these other hearings, so you know I'm just going to ask you if you have any objection to them being evidence in this hearing. Is there anyone from the public who's going to want to be heard on this case? Okay. Mr. Charlton, where did you say Exhibit C was from? Photos from environmental?
Yes, from environmental health.
Is that a department of Citrus County?
State.
A state, okay,
Yes, sir.
the Florida, okay. Sir, were you planning on testifying today, or were you going to leave that to Mr. Charlton? Okay, all right, thanks. Ma'am, do you have any objection to what's been proposed as Exhibits A, B, and C being evidence?
No.
Okay, thanks. Without objection, what's been proposed as Exhibits A through C are evidence? Thank you. Go ahead.
I conducted my initial inspection on February 23rd of 22, and I observed multiple campers on the property. The campers were connected to water, power, and septic. I observed several extension cords throughout the property connecting to the main mobile homes on the property. I also noticed the connection of the septic, and I contacted environmental health, and they did an inspection also. I spoke with tenants at the property as well, who stated that they pay rent to the property owner's son, Robert Spearing. I contacted him as well from contact information that the tenants from the campers gave me, and I explained the violation to him and explained that it appears to be a public safety issue with the septic hookups and things at the property.
So that's a separate case or a separate?
No, it's still in here for them living in it and
Okay.
the conditions that they're causing from living
Okay.
in.
Okay.
And I observed
The consequences of the violation?
Yes, sir.
Okay.
I observed 3 to 4 campers being occupied, people coming out of the campers and physically telling me that they are living in the campers and they pay rent at those campers. As of my final inspection on August 16th of 2022, there's been no change in the conditions of the property.
What was Robert's response to you?
He stated that he would work on to try to get, the people removed from the campers, that he wasn't aware of that violation or that code.
Were you aware that the property owner had passed away?
He did it. He did not at the time of the inspection, but he did state that to me, yes.
Okay, so you're aware?
Yes, sir.
You have no reason to believe otherwise?
No, I do
Okay.
not.
Just give me a moment to look through all this. And so I see another official notice, let's see, that was even dated yesterday. It says that there's raw sewage on the ground. Let me just take a look at these photos. Right, is it Crystal Spearing, Miss Spearing?
Yes, sir.
What's going on?
Well, the people that are living in a camper are not even supposed to be on the property. We have no idea who they are. No, the lady that's behind me, she is a tenant, her and her brother. Her brother is dying of cancer. They were gone at the time. My mother and father both are sick, so we had no time to go check on the property. We had got a call saying that there were other people on the property. When we went, the campers were there. We told them to leave multiple times, told them that they're not allowed to be there. They basically told us to shove it, that they're not leaving. We've tried multiple times to get them off the property.
What have you tried? Landmines?
We called the police to have them removed. We try to get a trespassing warrant against them. The police says we still cannot do nothing about it because they've been there so many days.
They're saying it's a civil issue, not a criminal
Yeah.
issue. Okay.
So we went and tried to be nice. We had got, what is it called, the paper? Notarized. Yeah, notarized eviction notice. And the police still saying that we cannot do anything about it.
I mean, have you filed an eviction lawsuit or an ejectment lawsuit or an unlawful detainer lawsuit?
We had the paperwork that they told us to print out. We printed it out. We filled it out. They said it was going to cost $385 to get it processed. When we went there,
Normally it
now
does.
it's not the right
You're allowed
paper.
to sign an affidavit of indigency if you can't afford it as well. And so I believe, unless I'm mistaken, so there's ways around that.
Oh, okay.
Just FYI.
Okay. Yeah, we're trying everything to get them off the property. I even told them I'll take my truck and drag the campers off the property.
So to the best of your knowledge, they're essentially squatters?
Yes.
Okay. And you don't know who they are?
No.
All right. Do you have are you residing on the property at all?
No.
Do you know anyone who is?
Yes.
And who is the one?
Her.
Who?
Deborah.
Okay. Okay. Okay.
Dolores. Sorry.
All right. These do look like some pretty serious issues from a code enforcement perspective.
We're every time we clean it, they destroy it back.
Okay.
Now the sewage stuff, we had no idea that they did that until they let us know.
Who's they?
The
county?
gentleman over here.
Okay.
Yes.
All right. Is it Dolores? You had raised your hand and indicated you wanted to speak. I'd sure like to hear from you. If you wouldn't mind coming up over here and swearing an oath. And
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, ma'am. Please state your name.
Dolores Ann Graham.
Thank you.
So can you tell me what's going on?
I've been living there for 4 years. I make sure that my brother, who has lung cancer, eats on a regular basis and has supplies that he needs. I'm a pastor, by the way. I also take care of my younger sister, who now is in a very deep depression, not very sociable. These people, I have an injunction against a coworker of theirs. they're not to come within 500 feet of myself or my family, or have any, think of the proper word, association with people that are associated with this one particular person that's in the injunction.
Okay.
And yet they continue to threaten with violence, with burning down the whole property, with weapons.
These are people who are actually on the property as well.
Yes.
Okay.
And they have told us repeatedly, we are moving, and they're not moving.
Okay.
They're meth addicts.
How big is this property?
2 acres.
It's 2 acres. So,
How big is the property?
Acreage.
2 acres.
2 acres. It's 2 acres.
sir, would you mind
1
stating
acre.
your name for the record?
He can't hear anything. He's recovering from COVID, and he's not
Can you?
hearing
Well,
anything.
he's provided testimony at the hearing. I need to know what his name is.
Robert Spearing.
Okay, Robert Spearing.
It was his parents that owned
Gotcha.
the original mobile.
Brother. Okay. I need to know.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Thank you. Okay, so now I understand a little bit more about this picture and how so many people are able to be on the, it's 2 acres, so there's a decent amount of real estate. But you've heard the testimony that the fundamental violation here is that there's a temporary occupancy of a recreation vehicle over the 2 weeks per year that's allowed.
Yeah.
Does that make sense?
Yes, but they don't even own this vehicle.
Well, I understand, Mr. Charlton. I mean, how many vehicles are being?
Right now, there's 3. There were 4.
That's what I'm wondering that.
Yeah, there's 3 mobile homes that we recognize, all non-conforming, but I suspect she lives in a mobile home on the property, not one of the RVs.
Okay, so how many vehicles are at issue here?
There are, I think, there are a total of 4 there,
Currently 3.
and 3 appear to be occupied. Yeah.
Right.
so,
Okay.
Yes.
All right. So it's really 3 vehicles that are violating this code section.
Yes.
That's the evidence. And you agree with that?
Yes.
And these are people who, I mean, do you know who they are? You have an injunction, I guess?
One vehicle in the rear, the worst one.
Mm-hmm.
He knows, he's aware of which one I'm talking about. It was supposed to be a worker to come in and demolish the mobile that's up front, that's taken apart, which you have pictures of, I'm sure.
Well, it sounds like we have a squatter issue. I
He
mean,
abandoned
okay.
his area.
Okay.
One is pulled up to front as far as they could get it with the family health and issues that are going on with Mr. Spearing's family. It's been between him when he has time, myself when I have time. And I think we've done a pretty amazing job repeatedly with what they've repeatedly destroyed.
Would
The one in the front, that camper that's in the driveway, right up in the front.
ma'am, I
is-
apologize. Hold on
I'm
one
sorry,
moment.
it's on my
I'd like to,
phone.
sir, you're from the state?
Yes.
Would you mind coming up and testifying? I just have some questions. I cannot compel a state official, but I would ask.
He's voluntarily speaking.
Yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
And can you please state your
My name is Matthew Lee. I'm an environmental specialist too with the Florida Department of Health.
Thank you. And so I see several official notices to abate a sanitary nuisance in my evidence. Did you sign these, or
Yes,
are you familiar with
I've
them?
signed a couple of them.
Okay.
I actually signed the one that you see from yesterday.
From yesterday.
We've actually had a case open on this property since February 23rd, and we've been going back about every 2 weeks. So there should be a notice every time that we've been there.
On the notice from yesterday, raw sewage on ground, fly breeding, household trash, rodent harborage. Is this all throughout the property?
Yes, it is.
And, I mean, when it gets to be raw sewage on the ground, I believe that's where things really escalate.
Absolutely, yes. There are multiple RVs where they're just dumping their black and gray water, or maybe they're even just using the bathroom on the ground. And then there are several 55-gallon drums that they've just buried in the ground, and they're just dumping it into, and it's overflowing.
And we have well water, sir.
I mean, so I guess I'm wondering where the state's coming in on this. What is the state prepared to do? Or
So right now, we're just constantly building our case. That's why we keep it in, giving these notices. We've got actually several problems with the property. Right now, they are also considered an unpermitted mobile RV park because they have too many structures there. Also, as she has noticed, they have a well. That would be an unpermitted limited use well as well. So we've got several issues going on, and we're just constantly building evidence.
It sounds like there's an immediate health danger.
This is an immediate thing, yes. And actually, I would almost argue that there has been no cleanup, really nothing really done.
Not true. That's false.
Well,
our pictures show otherwise.
All I can say is I'm looking at a picture of what appears to be a 55-gallon drum buried in the ground. I don't even know what it contains, but I doubt it's anything good. I'm looking at pictures of some drainage. I'm looking at, it's pretty grim. And one of the reasons why raw sewage is such a problem is because it could actually lead to not just people on the property being sick, but other people getting sick. And then when the rodents get in, who knows what they can spread. And then there's the mosquito issue. I don't have any reason to disbelieve these photos. What that means is that regardless of who is responsible on the property, according to the code, it goes to the owners. Now, I've heard that Miss Nancy Spearing has passed away.
Yeah.
When did she pass away?
She's passed away about 5 years ago.
5 years ago, okay. Has there ever been a probate or anything passing title of the property to anyone else, like her heirs? I imagine there hasn't been because it still says it's in her name.
Far as I know, that it's not. I know her daughter, Devin Spearing, said that she's part of the probate or whatever
Okay.
it is. But she gave all the stuff to my dad.
Okay.
But not signed over or anything like that.
I guess, is it Mr. Lee?
Yes.
The reason why I'm so interested in the state's case is because I think you have a lot more power. I think the state has a lot more power than we do, and I'm concerned with stepping on the toes. In other words, okay, we issue a daily fine. You guys have the authority to clean this property up, don't you?
Yes.
Is it the state's intention to do so?
We will eventually. Yes, we have been in contact with our lawyers. We have not started officially anything, but we wanted to speak with the county and see, how we should proceed from there. But yes, this is something that we believe if it is not taken care of, we will, go to legal action.
I'd like to ask the county some questions about this. What does the county want me to do, given the health concerns and understanding my authority? And having heard what the state has testified to. Mr. Lee, I don't mean to call you the state, but you know what I mean.
Remove the campers and, stop the occupants of them living in them, because that's causing a lot of these health conditions and public safety conditions.
How are you trying to do it? You don't need an eviction to remove stuff from your property.
Well, when we asked the police officer, when we called to see if we can get them removed, he says that because they've been on the property a certain amount of time, we had to give them eviction notice.
I doubt that someone from law enforcement is giving you legal advice, but maybe they did. You're saying they gave you legal advice?
That's why we went and got it, and now the other police officer came out and said, sorry, still cannot do anything about it. They told us to go get paperwork.
Well, what I'm saying is these are trailers, right? It's not necessarily the police sheriff's deputy's job to remove a trailer.
No, that's
there's
not
tow
what we're
trucks,
asking
there's
him.
all kinds of stuff. Okay.
We wasn't asking him to,
Move the
basically
trailer.
remove it
Okay.
himself.
Okay.
We've been given steps, We've been given steps along the way on how to rectify this problem.
Okay.
Each step that we take puts us backwards.
Right.
Starting with the notarized eviction notice. Then they tell us we have to get a regular eviction notice. Now they're telling we have to do a squatter's warrant. We cannot get a correct answer from anyone. This is the biggest problem.
Well, have you filed anything with the court, with the clerk of the court about this?
The
We've
one
been-
file
no,
that
not
they
yet.
told us to file, we filled it out, we took it, was gonna file it, and then she looked at it and says, this is not the right form, you can't do anything. I'm
So
like,
we
this,
went-
look, this is what you told us to get.
And we went to Angela Vick's office.
Yeah.
And
Okay.
they said, we cannot tell you which paperwork to get because it's a legal issue.
That's
So
that's
where
true.
can we
That's
go from
accurate. The
there?
clerk is doing her job.
You know? It's like the county's done a wonderful job with Rock Crusher. We want to continue that by getting these people off of this property in the proper manner. If he has the ability and he has the wherewithal to remove these campers that they don't even own, he has that right to do that.
Okay.
That will be done.
I need, what I'm going to do is, the time is 10:27. I'm going to take a 5-minute recess to review the code sections about this issue and about my authority. So we'll be back on the record around 10:32.
Thank you.
In the meantime, we'll go back on the record.
There he is.
The time is 10:32, and we're back on the record. I bring this hearing back into session. Mr. Charlton, first I'd like to ask you about the property. How many times have you been to the property?
Well, I've been to the property for four inspections.
Do you consider there to be a serious threat to public health, safety, or welfare on the property?
I do.
What is it?
It is the waste on there.
Have you personally witnessed that?
Yes, I've seen it when I was out there because I did the initial photo and contacted environmental.
Okay.
And from what I had
Have you seen what's
observed-
buried in the drums?
No, I have not.
Have you smelled what's buried in the drums?
Yeah, it is an odor.
Okay.
Yes, sir. And just the connection did not look right.
Well, you
for
say
the
an odor. What
septic.
kind of an odor?
Maybe waste.
Okay.
Just the connection didn't look right. That's why I contacted them. They're more of an expert on it than I am. The debris everywhere. We also have it for slum conditions. If that's a separate case.
Is there a case pending on that?
Yes, we do have a case for that also. And
Okay.
with the electrical cords running to some of the main structures on the property, the mobiles, that's what led me. They're you letting them run power to them so they can continue to live in their recreation vehicles.
May I hear from Mr. Lee again? Mr. Lee, this is just a couple of last questions. Have you heard anything you disagree with from Mr. Charlton?
No, sir.
And what do you believe that there is a serious threat to public health, safety, or welfare on the property?
Yes, I do.
And what is it?
So under our jurisdiction, it would just simply be the sewage, the waste, the fly breeding, and the rodent harborage.
And why are those serious threats?
Just for possible water contamination, like they stated, they do have a well. Contamination into our springs, on our watershed, breeding mosquitoes, possibly spreading diseases.
Dolores, does that concern you?
Very much so.
Okay.
We're all senior citizens besides this couple.
Is there anyone from the public who wishes to be heard on this case besides those who've already spoken? What's the county's recommendation?
Due to the nature of this violation, the Citrus County Code Compliance Division respectfully requests a special master assess a fine of $300 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given to the severity of the violation and respondents' actions relative to this violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
Pursuant to Section 19-55C of the County Code, I'm finding that the violation on the property presents a serious threat to the public health, safety, or welfare, and welfare. And therefore, I will order that the county may secure the property and take any action necessary to bring the property into compliance pursuant to that code section. The code section also states that making such repairs or taking such actions will not be a continuing obligation on the part of the county. It says the county may do that. So the county's going to have that authority. I do find that the property is in violation, and due to the serious nature of the violation, but also mindful of the fact that the order can be appealed, I'll grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $300 per day will be imposed. This fine will be recorded and will constitute a lien on the property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county ordinance or regulation. Here's the issue. If Nancy Spearing has passed away, as we all agree on the evidence, that means the heirs are the property owners, and the heirs are responsible. I don't know who the heirs are. But if this isn't fixed in 30 days, there's going to start to be a lien, or not a lien, I'm sorry, a fine that accrues.
Yeah.
And
About 24 hours.
well, I think because of the appeals period.
We can rectify the camper situation immediately.
Well, here's the reason why I'm not going to do that right now is I think I'm going to allow an appeals period if I have to allow for an appeal period.
Okay.
And therefore, I think that the county's authority to do what it needs to do to fix the property that I announced is also subject to that. Ms. Antrim, do you agree or do you disagree?
I agree.
Okay.
There is an appeal period.
Okay. Well, that's it then. It's settled. Thank you. I didn't see anybody. I asked.
No.
Next case on the agenda, Carolyn J. Oliver, Brandy Diani. I'm sorry, what is it? Dion, I'm sorry. And Lily Mae Oliver. Case number 216-7112. Alan Jonason, code officer on the case, page 28 of your agenda. I'm sorry, there is another case. It is 216-7415, and that is page 29 of your agenda.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
May you please state your name, please? Can you please state your name?
Brandy Dion Oliver.
Thank you.
Carolyn and Lily Oliver is deceased.
Okay, thank you.
Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. These are case numbers 216-7112, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and case number 216-7415, unlicensed inoperable vehicle, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address of the violation is 1988 West Test Court, Dunellen, Florida. Property owners are Oliver Carolyn J. and Oliver Brandy Dion and Oliver Lily Mae. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence, and this is for both cases, Exhibit A and Exhibit B. Exhibit A, photos taken during an initial inspection on 29 June 2022, compliance inspection on 13 July 2022, and photos of my final inspection conducted on 16 August 2022. Exhibit B, for both, a copy of both notices of violation, both notices of hearing, a copy of the posting affidavit for both cases, and a photo of the notice of hearings posted on the property.
These are identical exhibits A and B for each case?
They are not identical. There's different photographs.
Okay.
For
B is
each
the
of
same.
them. Yes, sir.
All right. So, ma'am, you've probably been paying attention to how we've been doing it. I would just ask you to take a look through these documents and let me know if you have any objection to them being evidence?
No objection.
Okay. Is there anyone from the public who's going to want to be heard on this case? All right, let the record reflect that there is no response. So, Ms. Oliver, I guess, based on what you said earlier, you're the sole owner of the property? Okay. All right. Okay, thank you. Without objection, what's been proposed as Exhibits A and B are admitted in each case.
On 29 June 2022, I conducted an initial inspection and observed the property to be in violation. On 29 June 2022, a notice of violation was issued for junkyard conditions and unlicensed inoperable vehicles, which is a violation of the ordinance listed above. On 13 July 2022, I conducted a compliance inspection and observed that the property remained in violation. I have had contact with the property owner, and as of my final inspection on 16 August 2022, the property remains in violation.
How do you know that car's inoperable?
Well, it was until the hood flew up on me.
I mean, it certainly looks.
But it still cranks up.
I was gonna say it looks like it did its job for a while. Not sure if it is now.
No, actually, the motor is on another vehicle, under another vehicle to make a doom buggy.
Oh, well, that's. Oh, okay, I see. Well, Miss Oliver, what's going on?
Well, actually, now the one pile of stuff is from me, and I called the police on myself because I almost set the house on fire. But,
Man, you should never call the police on yourself. That's.
But the rest of the stuff is from my ex, which we're going through a domestic dispute.
Mm-hmm.
I had to call Florida Power because he had it hooked up wrong, and they had to come out and get on to him about that. And this was my next step to do this, but he's in jail, and they were supposed to come out and look for a gun because he pulled a gun on me, and he's still in jail. But if I can, I will remove it all right now, and him too. But every time we try to remove something, he either crowbar my door. I call the police. They say, "Oh, he can do that because he live here."
Well, no, you're the owner of the property, so
yeah, I've been.
Doesn't sound like there's anyone else, and
he tried to run me over with cars. I showed him videos. Finally, with him pulling the gun on me with my kids.
Okay. Well, you understand the cases that are here.
Mm-hmm.
One of them is easier than the other, probably. I assume. I mean, you've got an inoperable vehicle. It's got to go. That's basically how that works. And then on the junkyard conditions, I've seen worse cases. This isn't that bad.
And some of that stuff on that pile is from where we cut trees in the back and cleaning it up because the guy next door said, "Oh, we're gonna clean it all up and we're gonna rent a U-Haul, a waste thing."
I don't even think that's the biggest issue. I mean, it looks like.
And then we get into it, and he drags his lawnmowers off my property without my.
Well, there's a lot of stuff though. It's miscellaneous stuff. I don't.
Yeah, he was a mechanic, and he was taking pieces off to sell. And
okay. Well, look, I mean.
But as speak, it's being loaded up on a.
This isn't really a disputed case, so the question is, how much time do you think you need to fix it?
My only problem is gonna be that pile. I asked several people to come with a bulldozer and help me get rid of it, to put on the other trailer that's over there wrapped up with the weeds because I went out there and it was a snake and I'm too fat to be running. So.
I
I'm not
don't know about that. When there's a snake coming at you, no one's too fat to run. But so,
as I speak, we are loading the cars up and we already put it inside the car. All the stuff. We put it inside the cars to take across the scale.
How much time do you think you need?
2 months.
Okay.
Just to make sure I have everything.
I can do better than that. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per violation, along with the administrative cost to begin after the date you deem sufficient to abate the violations. This amount was selected based on the actions of the property owners once they were advised of the violations. This amount is appropriate given the severity of the violations and the respondent's actions relative to these violations. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So I am going to adopt the county's proposed findings of fact, and in each case I'll find that the property is in violation. However, I'm going to give different time periods to comply.
Okay.
In case number 216-7415, the inoperable vehicle, I will grant 60 days from today to abate the violation. And in case number 216-7112, I'll grant 90 days, that's the junkyard conditions case, from today to abate the violation. In each case, if the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Ms. Oliver. And the county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of its first recording. And Ms. Oliver would be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. That's it.
Thank you.
Thank you.
Thank you. Thank you.
Next case on the agenda, Brian Snell, case number 216-6719. Alan Jonathan, code officer on the case, page 31 of your agenda. Joanna Coutu, land development director, expert on the case.
Mr. Snell, I'll swear you in while we're waiting. I'll swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And please state your name for the record.
Brian Snell.
Thank you.
Thank you.
Alan Jonathan, Citrus County Code Compliance Officer. This is case number 216-6719, special requirements for all accessory structures, violation of Citrus County Land Development Code 3102A, or Alpha. The address is 7055 West Gator Lane, Crystal River, Florida. Property owner is Snell Brian. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 20 June 2022. Photos taken during a compliance inspection on 21 July 2022. And photos of my final inspection conducted on 16 August 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence. Take as much time as you need.
From two angles, I guess.
No objection.
Okay, thank you. Is there anyone from the public who's going to want to be heard on this case? Let the record reflect that there is no response. County's exhibits A and B are admitted as evidence.
On 20 June 2022, I conducted my initial inspection and observed the property to be in violation. On 20 June 2022, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance listed above. On 21 July 2022, a compliance inspection was conducted with little change to the property. As of my final inspection on 16 August 2022, Their property remains in violation, but he has made tremendous progress.
And is there anyone else from the county who wishes to testify?
Joanna Coutu, Land Development. It's rural residential with mobile home allowed. It should be otherwise vacant. There is no established principal use at this time.
Thank you. Mr. Snell, it sounds like from the county's perspective, there's been improvement. Are you making efforts?
I've been, yes.
Yeah.
Yes, I can barely walk right now because of it. But I didn't make the finish line, but I'm talking like really, really close.
Okay, and how much time do you think you need?
I would give me like, just to play it on the safe side, 2 weeks. No.
Well, it's rare that I would ever.
How about this? How about that's more than enough time.
I'm not doing 2 weeks.
Okay, how about
gonna,
a week?
Is this a joke?
Be more.
It's gonna give you more time.
Oh shit! I'm thinking.
No,
I was
no,
going
no.
too much.
Based on what you said, I know how much time
I was shooting
I'm
over
gonna.
the limit. I was like, wait.
Well, okay. So
My bad.
it sounds like a month will be enough, but
I'll take 60 days. No, how about
the reason why
I
I'm
don't
going
know
to
how much
do
time you
here
want.
here is the reason why I'm going
If
to
it's
do
over
60
2 weeks,
days.
I'll take
The
it.
reason why I'm going to do 60 days is because we're in storm season, and you never know when one of those storms will come through and then put a delay in everything. I'm sorry, Mr. Jadison. So, what's the county's recommendation? The goal is compliance.
Yes,
All right.
sir. Absolutely. Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owner once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I find that the property is in violation. The owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Mr. Snell. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the day of first recording, and the property owner shall be responsible to pay all costs required by county law. Thank you.
Thank you.
Okay, so that last part, when it's cleaned up, I call you guys?
Yes.
All right.
Yes. Straight down. Next two cases on the agenda. Keith Henry Taft, case numbers 216-5415 and 216-5416. Code Officer Amy Becker, pages 33 and 34 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name.
Keith Taft.
Thank you.
Good morning.
Good morning. Do you want to hear them both together?
Yes.
Okay, they're two separate.
Unless there's an objection, Mr. Taft, do you have an objection to having these both heard at the same time, or do you want to split them up?
Whatever works for y'all.
Okay, then I'd like to hear them together. And
Okay, they're two separate addresses, okay?
oh, okay.
So I'll make that. All right. Case number 216-5416 is accessory uses or structures, a violation of the Citrus County Land Development Code, Section 3102A, and the address is 4185 North Gary Point, Crystal River. Property owner is Keith Henry Taft. Case number 216-5415 is abandoned, unserviceable, and unlicensed vehicle, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41, and the address is 4165 North Gary Point, Crystal River. Property owner for both properties is Keith Henry Taft. I have good service via both cases, a signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence for both cases. Exhibit A, photos taken during my initial inspection on May 27th, photos taken on July 15th at my corrective action inspection, and photos taken on my final inspection on August 16th, 2022. And Exhibit B, a copy of the Notice of Violations, a copy of the Notice of Hearings, and a copy of the signed certified mail return receipts, signed for on July 26th, 2022.
So both of these exhibits will be different for each case, correct?
Correct.
Okay. Sir, you've been here. I'd like to ask you to look through these documents and let me know if you have any objection to them being evidence.
Hi, Mr. Taft.
Hey.
It's nice to meet you.
Nice to meet you. Okay. So two separate
This
ones.
is the storage on the
Okay.
vehicle, and this is just for the Blazer.
Okay. So doing both at the same time. Obviously.
Take your time.
Pictures are there. Okay. And this is 715. Do you have a picture of the vehicle when you first contacted me?
Yeah.
Okay, yeah.
And I know the RV's gone.
Okay,
There
yeah,
it is.
yeah, okay, that's fine. This is the so-called vacant lot.
Yes, sir.
Don't need to look at them, just verify if I guess they're mine. Somebody's finger on that one. I need to look at that.
That's just the notice about that was signed, that you signed for. And then this is just for him to show him both your property so he can see it.
Yes, ma'am. Okay.
Any objection?
No.
All right. Is there anyone from the public who's going to want to be heard on this case? Let the record reflect that there is no response and no objection to the exhibits. So exhibits A and B in each case are admitted.
That's the vehicle.
Okay.
This is the storage on a vacant.
Mhm.
This is a map just so you can see it. So they're right
Is
next
the
to
map
it.
an exhibit?
We can make it. We can
I don't
make
want to
an
look at it
exhibit.
unless it's an exhibit.
Okay,
Has
it
he looked
is.
at it?
Yes,
Okay.
he has.
All right. So I'll make this exhibit C.
That's fine.
Okay.
And that's just both the properties, just so you can get a visual.
They're next to each other.
Yes, they are.
Thank you, Mr. Taft. Okay, so as far as the untagged vehicle, I conducted my initial inspection on May 27th, and there was a Blazer on the property with no tag. And I've had contact with Mr. Taft, and he's working on getting, in a summary, he's working on getting it tagged. And then as far as the other property that's located at 4185 North Gary Point, I conducted an inspection there for the LDC violation for accessory structures. And I observed a walk-in cooler on a concrete slab, a truck and other items on the vacant property that is next to 4165.
You didn't even mention the most important item. What do you think that is, Mr. Taft?
I don't know, I'm curious.
Trampoline. Okay? So
The trampoline,
I
yes,
don't
of
see
course.
this photo and ignore the trampoline. But all right.
Yes, the trampoline.
Family man of 4 kids.
There you go. There you go. Okay. So, what do you have to say, Mr. Tapp?
Well, I know you're doing them together. I just want to address the vehicle one first because I do have a question or two. On the vehicle with no tag, my daughter just turned 16. It was given to her by her grandparents, and I am making her get a job and buy her own tag and registration and insurance. She's recently got the job. She just recently turned 16. I don't know how long, but very shortly she will have enough money to get it legal. It is, what do you say, it's not a junkyard vehicle. They are running vehicles. Just teaching my child a life lesson, making her be responsible for paying for it. And if it is not done in time to be compliant, do I need to A, put it in a storage unit and get it off my property, or B, put a privacy fence around it?
What's the answer to that, Ms. Becker?
I believe it'll be able to be done within the time frame, within.
What? Well, if it's not, what
If
does he
it's
have to
not,
do to abate it?
According to the ordinance, it would have to be in an enclosed garage, according to the definition, or an enclosed structure, according to the definition.
Or removed from the property.
Or removed from the property.
And a privacy fence will not do the trick.
Correct.
Okay.
Okay. Do you have any other questions about that one?
Not about that one, no.
Okay. And so let's talk about the accessory uses. We've had some other cases with that code section today. I don't know if you heard them.
Yes, been paying attention.
what's your position on this case?
This is a vacant lot?
Correct.
Okay. I spoke with her. I've been to this building to deal with whatever people here and paperwork necessary to take care of it and be compliant. I've had several calls from my Karen of a neighbor on stuff over the years. Several times code enforcement has been to my house, my properties, and there has never been a code violation on me. I've always tried to be compliant and do what needs to be done. There's never been a code violation. A dozen times later, now there is, and it has to do with this vacant lot. I had no idea that it was 2 addresses and zoned as 2 different lots was an issue. If I would have been told sooner, it ought to be taken care of. But as soon as I had found out that what I needed to do was contact a surveyor and have it replatted as one address,
I don't think it needs to be replatted. Is that what the county's position is? To make it one address or one lot?
It depends on what he wants to do on the vacant lot. If he just wants to have structures there that are associated with his house next door, there is a unity of title form he can fill out.
Yeah.
If he wants to park vehicles over there, that's where he's going to have to talk about replatting. But it sounds like he's not doing that. So I think you want to keep the slab and the cooler. Is that what you want to keep them there if you could?
Okay, well, it's a little confusing because it's not 2 different lots separated. They are together as my 1 yard, so.
No, so I think what they're saying is that these are platted as 2 different lots.
Correct, they are.
Okay, well, that's the issue.
Yes,
so,
that's the issue. That's
so
why.
Even though you can walk from one to the other, it's irrelevant from the platting perspective.
Well, the way I understand it, I was told I have to remove everything off of that lot. I cannot use it.
But we're talking
period.
through this, so we're finding the solution. So what has been indicated is that depending on how you want to use the vacant lot.
Well, I want to use it as it's currently being used. Is that
well, then I guess you would have to replat. I mean, is that the county's?
What else is on
because I'm parking a vehicle on it? Is that what the problem was?
No, can I see one of the exhibits to show her?
Yeah, please. This is it.
I mean, I saw some, it's not going to help with junk and things, but it would allow him to have
Okay,
apply
can I
for
elaborate,
permits.
please? Because
hold on a second. Let's let the county look at this, and then we'll all be on the same page.
This is on that site?
Correct.
Okay.
So you can walk in forward, and there's 2. There's the lot.
Okay, so if he did the unity of title form, which is just a form you fill out at the time of permitting, it will allow him to use the second lot for accessory structures and apply for permits for those.
So one of his questions was, would he be able to store cars there or park cars there?
Yeah, not store, park.
I understand.
Right. They're not really structures, as long as it's not, a car storage lot, then sure.
Yeah, well, that lot is part of my driveway, is why I asked.
Yeah, we couldn't do a driveway there, but if you used your existing driveway and you drive over the line, sure. I mean, we're getting in a little gray.
But what you're basically saying is that based on the use that you see in the photo, a unity of title form may do the trick.
It would do the trick, other than, some of the items that are sitting around that may be classified in another case as junk. But right now, it would allow him to do
this
it would allow him
violation.
to do after the fact permits for the structures on this lot, yes.
Okay. So what they're saying is it would abate the violation if, after you did the unity of title form, you then, and it was approved and no problems there, you then would have to get after the fact permits for how you're using the property, okay?
Okay.
But once that was done, and I assume it could be done in a matter of months.
Right, the unity of title is part of the building permit. So when he applies for a building permit for the slab, for example, you would fill out the unity of title saying, I'm looking at this as 1 lot forever, even though it's 2 lots. That's how it's treated. And you wouldn't be able to subdivide it again. It would be 1 lot development-wise. And then you could get permits for this and abate this violation.
Okay, well, I've been through numerous options, and this one was not presented
That's
to me
okay.
yet.
It's presented now, and this often happens at hearings. So my question is that something that you'd be interested in? And if so, I think that would inform how long, I'd give you enough time to get it done.
Okay, well, the only option I was given after the numerous rejections was to replat it and have a surveyor. Surveyors were 6 to 8 months out.
It's totally irrelevant.
Well, I'm just saying I already had an appointment with a surveyor to take care of it and be compliant.
That is relevant.
Okay.
So,
now that I have this option, I would probably prefer to do that because of the cost.
Good, okay.
The financial end of it.
Yeah, replatting is not a pleasant process.
No, no, nor cheap. So, but I have been in compliance as much as I could possibly
Does the county
be.
believe that 2 months would be enough time, or, you know?
I'm a little worried about that cooler and the age. It might be a little difficult to get some engineering for that structure. I don't know where that
Can
came
I see
from.
the exhibit again?
I apologize. I took
No, it's okay. I'm just curious what this is. The cooler. Oh, I see. Okay. So you're dubious that a permit can be issued for this?
It's not that I'm dubious a permit can be issued. It's just that he's going to have to get engineering for it. And because of what it looks like the age in the pictures, it might not be something he can instantaneously get. The slab is going to be an easy permit.
My turn?
Yeah, if you'd like to be heard.
Okay, the slab, the foundation was already there. I guess this was the problem where it was 2 addresses and 2 lots. That's where the other old resident was before I bought the place, so the concrete was already there. I just cleaned it up and made it useful. I did put the walk-in cooler together and put it up, but it's a prefabricated building. It's did not require any skill saws, hammers, or levels or anything like that to put it together.
Do you still have the plans for it?
No, I do not have a plans. I did not acquire a permit for the walk-in
No,
cooler.
I mean, when you bought it, when you said you
I
put
bought
it together,
used.
did they give you a kit or
I bought
anything?
it used. I did not buy it new.
And that's the county's point. The slab's not an
Okay,
issue.
so I need a permit for the walk-in cooler. I mean, I'd be glad to take care of that. It's not a problem.
Yeah, that's the one that might
The
take
reason
time.
why she's bringing it up is that in order to get the permit, there may be more time needed to obtain the engineering so
Okay.
that a permit can be granted. So that's to inform my decision on how much time to give you.
Okay.
Okay, well,
Well, my question was, I guess, probably to the building department or some other department here about the concrete foundation. Do I need a permit for that if it was already there?
It should have been removed because it's a vacant lot, so I don't know. They'll have to make that decision. You
Okay.
can talk to building division.
all right, what's the county's recommendation on these cases?
On case 216-5415 and case 216-5416, the Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per case, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
All right, I am going to find that the property is in violation in each case. However, again, based on Mr. Taft's testimony, I'm going to give a different time period in each case to comply. In case number 216-5415, the unlicensed vehicle, will grant 60 days from today to abate the violation. If the violation is not brought into compliance, well, we'll get into that. And then in case number 216-5416, I'll grant 120 days from today to abate the violation. In each case, if the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on Mr. Taft's property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law as may become necessary. Okay, thank you.
One question, do I speak with Miss Amy Becker about the follow-up on this, or are y'all gonna mail me
I encourage you to.
paperwork?
Yes, go ahead.
I'm going to talk to you when you leave.
Okay, now,
Follow me out.
awesome, thank you.
Next case on the agenda. Angelina Williams, case number 216-4338, Code Officer Matt Hampton, case number 36 of your, page 36 of your agenda. Expert on the case, Joanna Coutu.
Yeah. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name.
Angela Williams.
Thank you.
Thank you.
Morning again.
Morning.
Matt Hampton, Citrus County Code Compliance Officer. This is case number 216-4338. Special requirements for all accessory structures. Violation of Citrus County Land Development Code 3102A. The address is 6547 South Premier Avenue, Homosassa, Florida. Property owner Williams Angela. Had good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A is photos I took during my initial inspection, May 10th, 2022. Photos I took for the corrective action inspection, July 19th, 2022. And photos I took during my final inspection on August 16th, 2022. Exhibit B is a copy of the property appraiser's report showing the property is a vacant parcel. Copy of the notice of violation, a copy of the notice of hearing, a picture of the notice of hearing posted at the property, and a copy of the posting affidavit I completed on August 4th, 2022.
Ma'am, again, I'd just like to ask you to take a look at these things and let me know if you have any objection to them being evidence.
No, sir.
Is there anyone from the public who's going to want to be heard on this case? Okay, let the record reflect there is no response. Without objection, what's been proposed as Exhibits A and B are evidence.
I conducted my initial inspection May 10th, 2022, and observed the property to be in violation of the Land Development Code listed above. There was an RV, a bus, appliance, and other items on the property without a principal use structure. I conducted a corrective action inspection July 19th, 2022. Notice of hearing was issued July 19th, 2022. I've had no contact with anyone in regard to this property. As of my final inspection, August 16th, 2022, there has been no change to the property.
Ms. Williams, what's going on?
I took down the screen room, I took down the tent, I've sold the camper, it's being moved this weekend, and the bus is going to a scrapyard. And then I will be selling the property.
Does the bus work?
It needs a sensor for the transmission. I'm using it as a storage unit.
Wow. How'd you get it?
I towed it.
Oh. The way that Ukraine tractors tow Russian tanks, I mean, was it with anyone's permission, or I'm just...
No, it was just a big tow truck.
Wow, that's great. How much time do you need to fix the last stuff?
About 30 days.
Okay. You said 30?
Mm-hmm.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it is a respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. And if the violation is not, I'll grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be assessed. The fine would be recorded and constitute a lien on Ms. Williams' property. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner would be responsible to pay any cost required by county law. Thank you.
Next case on the agenda, Jenna Holfeld, case number 215-9287, Code Officer Jillian Nocella. Page 19 of your agenda. Expert on the case, Land Development Director Joanna Katu.
What page, I'm sorry?
19.
19.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Your name, please?
Jenna Holfeld.
Thank you.
Jillian Nocella, Citrus County Code Compliance Officer. This is case number 215-9287, special requirements for all accessory structures, violation of the Citrus County Land Development Code 3102A. The The address is 7904 East Gator Court, Inverness, Florida 34453. Property owner Jenna Hofelt. Good service via signed certified mail return receipt. I would like to authenticate the following documents. Request they be admitted into evidence. Exhibit A is photos taken during an initial inspection, February 23rd, 2022. Photos from subsequent inspections on March 24th, 2022 and July 22nd, 2022. Photos from my final inspection on August 16th, 2022. Exhibit B is a copy of the notice of violation, notice of hearing sent to the property owner, and a copy of the signed certified mail return receipt.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
Yes. Yeah, thank you.
Any objection?
No.
Okay. Is there anyone else from the public who's going to want to be heard? Okay. Ms. Hofelt, when did you become the owner of this property?
When I was like 14.
That's what I was kind of wondering. All right.
My great grandma gave it to me because
Okay.
she's 94 years old, so she lives with
Wow.
my grandma now. So
Okay.
she has like no use for it anymore, and she wanted to stay in the family.
Okay.
So
And
she
how
was
old are you now?
20.
All right. Just checking. There's different rules. If you still were under 18, actually, it would be kind of a different story as to whether you could technically represent yourself for this. So I'm satisfied. Please proceed.
An initial inspection was conducted February 23rd, 2022, and it was observed that there was a travel trailer, car, and shed located on the vacant property, which is a violation of the Land Development Code mentioned above. Follow-up inspections were conducted on March 24th, 2022, and July 22nd, 2022, and no changes had been made to the property. As of my final inspection yesterday, August 16th, 2022, I observed 2 sheds to remain on the property.
Have you seen improvement?
There were a couple items from that initial inspection that were removed,
Okay.
and from what I can tell, it's pretty overgrown, but it just looks like it's the 2 sheds. I'm assuming that front structure is a shed that remain there.
I mean, I guess it's hard for me to tell. There's what looks like an interesting trailer with a green metallic roof. Is that still on the property?
I don't believe so,
No,
no.
we removed that.
From what I
Okay.
can see, no.
All right. And have you had contact with the property owner?
I have not, no.
Okay. So, Ms. Hofelt, what's going on?
So when I turned 18, I moved out, but last February, the house that I rented, she just up and sold it randomly. So I got a letter from the new owners that I had to move out. So I didn't know you weren't supposed to have a camper, so we got that camper and we moved it on there, and I was actively looking for a mobile home to actually move on there. Yeah, but I know March 3rd, March 2nd, I purchased a mobile home. March 3rd is when I got it registered. And we've been kind of just trying to get that on there. I did move the camper. They did tell me to move that, and I moved the car. Those are gone. I plan on tearing down the shed. I just haven't had the time and tools to really do it, because that shed's been there for over 30 years.
They owned it for 50 years,
So it's been there for a long time, and it's fallen apart. And
I did skip a step. Is there anyone else from the county who wants to testify on this, which will help me?
Yeah, Joanna Coutu, Land Development. I do want to testify on this because I can tell you that we did get a mobile home application permit on May 11th. It was completely incomplete. That's weird. It didn't have any plans.
That would be the same as blank.
Yeah,
I
yeah,
guess.
blank. It really was. We got the application and we didn't get plans, didn't get a site plan. It's in a flood zone, so we need a little bit of that information. So the contractor was notified on May 16th and again reminded on June 1st. Still nothing. So although I think there's been an attempt in that the application was received, nothing was received to review. So it's been denied since that
So
time.
basically what your testimony is there
wasn't an
sort
effort.
of was an attempt.
Yeah. Right.
And it reminds me a little bit of the South Park episode where the gnomes steal all the underwear. And, their
South
big
Park.
idea is they'll make profit somehow, but they don't know how. It's step 1, steal the underpants. Step 2, question mark. Step 3, profit. Here it's step 1, drop an application off. Step 2, step 3, it's permitted. So,
Right.
Self-preference.
I would like to hear, ma'am, you indicated that you wanted to speak to this. I'd love to hear what you have to say.
Ma'am?
Oh, yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your name, please?
Brandy Dugan.
I'm sorry?
Brandy Dugan.
Thank you.
Okay. We submitted it, and then we called like a week later to see what was going on. They said it was denied. So, they gave us one reason it was denied. The guy that sold us the trailer, Chris, he works for a place called Home for Hopes. He's been helping us every step of the way. He calls every week here too. We were given one set of information, so we went to him for him to help us get it set up. He called, he was given something totally different than what we were told, so then he tried to set it up. And then when we got back a hold of the county again, it wasn't that, it was something different. So along the whole line, we've been given different things, and every time we call and try to come in and either submit or get the paperwork, oh, that's not what you need, this is what you need. So yesterday, we dropped off the engineering. We went and had an engineer look at the structure, make sure it was sound to live in, sound to move, everything.
Which structure?
The mobile, because it has to be moved to her property.
Okay, right.
And that is all we thought we needed at that point.
Mhm.
And when we turned it in, the lady said, oh no, you were denied across the board. And I said, well, what does that mean? Because I could have been working on every other step of this at the same time. And she said something about flooding and a few other things that we still don't really understand.
Okay. What needs to be done to bring the property into compliance?
The mobile home needs to be put on the property. The items that are there can't be there until there's a primary use.
But that has to receive a permit of some kind, or
The
do they
mobile
just?
home would, yes,
Yeah,
correct.
so they need
Needs to be permitted. Or remove the items off, yes, correct.
Does that make sense?
Yeah, but
Yeah,
we
but
submitted
how-
the permit, we just need to know what went wrong with the permit that we need to fix so we can get it to pass.
And so then the question becomes how long you need to figure that out. So
Yeah, because all that's on there is her dog kennels and the sheds that were there and have been there for 50 years.
right. So the two issues, there's two ways to fix it. One you could get done very quickly, but it sounds like, which would be to just remove the stuff that's there. But you don't want to do that, right? You want to use it.
Well, the shed in the front that's actually falling apart, I plan on actually tearing that down because there's
Okay.
really no use for it. It's falling apart.
Okay.
But the other shed is still
Yeah.
great.
So one
It's-
you want to keep,
Yes,
right?
one I would
So-
like to keep.
So assuming you want to abate the violation that way, it sounds like you need a little bit of time to sort everything out with the county.
That's what we've been trying to do. I've never done it, she's never done it.
Right.
And sometimes we come in here and they look at us like we know, and I'm like, I don't know, it's just been very hard. If
Yeah,
I know
it's-
what we
it's a
need to do,
process.
we'll do it.
Yeah, I just need to know what I need to get done real fast so I can get it all done and have it to submit the new permit.
And
And
she's like living off couches, her dogs are like here and there because like.
Well, I've got a 1-year-old. I know what it's like to live on a couch.
Well, I got 6
what-
kids, so she
well,
can
yeah,
bring all the dogs to my house, so.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions. We would ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I don't think that either of the remedies here is that complicated. I think you'll find if you stay in touch with the county on what they need, they're going to tell you what you need for the permit. And I don't think it would take longer than 2 months to do.
no, I don't think it will either. I just need to, like I said, if I can figure out what I actually need to get the permit like submitted so it'll get accepted, I can get that done. I just have to kind of understand because I was told I needed a mobile home inspector to come, and I called every mobile home in Citrus County that I could think of inspector, and every time I told them what I needed, they're like, we don't know what you're talking about. So then I called again, and that's when Chris called for me, and then they said something about the engineer, and then that's when I got a hold of an engineer, and he came out to the mobile home and let me know it was sound to move, and I just turned that in actually yesterday because I got it in yesterday.
Okay, that sounds like an important component, and that you're already on your way.
We just need the steps that have been denied so we know who we need to call.
Right.
And because that's what we're getting. One day it's this.
I get it. I mean, again, I don't think it'll take longer than 60 days. I think a permit. So, look, I'm going to find that the property is in violation. I'll grant 60 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $50 per day gets imposed. This fine would be recorded and would constitute a lien on Ms. Hofeld's property. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by the county if it becomes necessary.
Alright.
Again, I really just encourage you to keep in close touch with the county on this. Yeah?
Well, I'll definitely do that. I was working with George. I don't know what happened.
Oh.
Yeah,
He's
no longer a code
he's
officer.
retired.
That's, yeah.
Okay.
Yeah,
Okay.
because we were just here yesterday doing the same thing, and we still don't understand what they want us to do.
Sorry, I'm not in building it. It's hard. I'm trying to help you.
No, it's okay. I can get it done. I just have to, once I figure it out, I'll have it.
Well, this hearing's over, but I do encourage you to
Yeah.
daily contact.
I will.
Okay? Thank you.
Thank you.
Next case on the agenda, Jonathan Curtis Nave, case number 216-6456, Code Officer Amy Becker. Page 26 of your agenda, expert on the case, Joanna Coutu.
This is going to be a section 4002 of clearing the property, and I know you had dismissed the other one. Did you want me to present this? Because
Well, yeah, I don't know what the facts are yet. It could be a genuine violation.
Okay, all right. Case number 21.
It's up to the county, by the way. I mean, if you guys think that it's consistent with the prior finding, I'm not going to make you present it, but...
No, I mean, I think I have a good case.
Okay, all right.
All right, so case number 2166456, a violation of the Citrus County Land Development Code, section 4002, site development without a development order or permit. The address is 8424 West Tawny Rose Lane, Crystal River, Florida. The property owner is Jonathan Curtis Nave. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on June 16th, 2022. Photos taken on July 15th, 2022 at my corrective action inspection, and photos taken on my final inspection on August 16th. Exhibit B, the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt signed for on July 30th, 2022.
All right. Is there anyone from the public who's going to want to be heard on this case? I'll let the record reflect that there is no response. All right. Without objection, what's proposed as Exhibits A and B are evidence.
I conducted my initial inspection on June 16th. I observed a vacant property and a large portion of the property had been cleared, observed downed trees. While researching the property, I found that there was no permits issued. As of my final inspection, there has been no change. I have had contact with the owner and he's aware of the violation.
What was the owner's response?
He's building a house with a company called Boxable. And that company's structure has not been approved for the state of Florida yet. So he's put a deposit down and he's waiting. He's thinking a year and a half, 2 years.
He put a deposit down with Boxable?
Yes.
Okay. I mean, what is he... So he conceded the tree removal?
Pardon?
Did he concede the tree removal?
Yes.
And
yeah, yes.
he explained why?
Right, because he's building... Well,
a year
he's
or a year
having-
and a half ahead of time. Is
Right.
a Boxable like a tiny home or something?
Yeah, and I want to show you. I have a picture. It's very interesting.
Okay, let's...
Like container homes?
Interesting, interesting. I've seen those. I mean, they can get very elaborate on the inside.
The engineering's complicated, and it sounds like the Florida Building Code hasn't approved this.
I see. I want to see it.
She wants to show the picture.
Once I got everything I need, I'll just call you when I get done.
Okay. Thank you. Thank you so much.
Thanks.
And this will be Exhibit C,
Okay.
boxable.
I don't think anyone's objecting, so.
It's boxable. It can be set up in hours. And you get the slab, and then you just bring it in, and you set it up, and you have a small, tiny home.
The market provides.
Oh, I apologize, Beth. Did you want to see it?
No, I have actually Googled those and I'm familiar
Really?
with what they are.
Oh, okay.
Are they considered a manufactured home or a mobile home or?
Well, we're not sure what they're considered yet because they don't have Florida approval yet. So we're not sure what they're considered yet.
I'm interested. These are
Because
interesting.
I guess the question would be as far as hurricane standards and such. So he's very excited. He couldn't be here because he's out of town.
All right. Now to the legal analysis.
So, yeah.
A site development plan shall be required for any multifamily residential development and non-residential development. The following are exempt from this requirement: agriculture, single-family dwellings on either lawfully platted or recorded lots. I don't know if this is platted or recorded. Or lots in recognized unrecorded subdivision, duplex residential structure, lots, accessory structures, and other uses that do not require extensive review by county staff. Uses that do not require extensive review by county staff and can be approved through the building permit process. So, were you here for the last case under this code section?
Yes.
Well, I'm just wondering.
Yes, I was.
Factually, how is it different? Why is this a good case, but the other one?
I think it's a good case because, ta-da, expert witness.
No, there's not a use here. So the exemption, I think A is more applicable. There's no use exemption here. So A, they don't have one.
And did you state that these may not meet the building code?
He hasn't applied for that. That's not what we're citing. It's just tree removal.
No.
And
All
he
right.
has been told, Carl Jones did speak with him, did email him that there was going to be a problem meeting the Florida building code.
Okay.
So it would be something that apparently wouldn't be easily reviewable if it did come under B. But according to Ms. Cotu, it comes under A.
Right, it comes under A because there's no specific use here. If he had
Okay.
applied for a permit, we'd be talking differently.
All right,
We're
let me look
not.
at A. The reason, honestly, I was prepared to rule in the county's favor until Ms. Becker brought up the boxable. Because I think that is a use on the record here says admissible, but let me look at A. No development allowed by this code shall be established, changed, or altered, and no building shall be used, occupied, or altered until there is first on file a site development plan. Nothing. I think that's creative.
Never not be called creative, but if he'd applied for a permit for the boxable, we might be talking differently. But we have a someday I want to do this situation, and
I'm going to look at the new code section for a second. It's really clear under the new code section. They do not require extensive review. But it does sound like there's a building code issue. Testimony is that it says uses. I'm going to deny the case.
Okay,
Yeah.
I'll send a new notice of violation with the new code.
That's your choice.
Thank you so much.
Next, two cases on the agenda. Lorna A. Dwyer, case number 216-2591, and case number 216-2592. Code Officer J.C. Charlton, pages 12 and 13 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, please?
Lawrence Dwyer.
Thank you very much.
Good morning.
Good morning.
These are two cases I received from Code Officer George Pearson before he retired. This is case numbers J.C. Charlton, Citrus County Code Compliance Officer, case number 216-2591 and 216-2592, accumulation of junk and debris, in violation of Chapter 20, Article 3, Section 20-31A, and excessive growth and accumulation of vegetation. Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 7647 South Viewcrest Loop, Floral City, Florida. Property owner Lorna A. Dwyer. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during an initial inspection on April 19th. Follow-up inspection on May 13th, corrective action inspection on June 15th, and a follow-up inspection I conducted on July 29th of 2022, and my final inspection on August 16th of 2022. Exhibit B, notice of violation, notice of hearing, a copy of the continuance letter, photos of the posted property, and a copy of the posting affidavit I completed.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection. I'm sorry, sir, did you have any objection?
Nope.
Okay. Without objection, what's been proposed as A and B are exhibits. Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response.
An initial inspection was conducted on April 19th, 2022. Violations of overgrown lawn and junk and debris were observed at the property by Code Officer George Pearson. A continuance letter was granted on July 5th. There has been no contact with the property owners that I have had. While posting the property on July 29th, I observed the violations for both junk and debris and overgrown lawn. As of my final inspection on August 16th of 2022, the property remains in violation with overgrown lawn in the back of the home and debris in the back of the home as well.
Well, Mr. Dwyer, what's going on?
As far as the debris in the back of the home, we talk about the chicken coop we have there?
No, it looks like a broken, maybe scrap wood, or broken, maybe privacy fence, or, because I do see but it looked like a structure or something. Maybe it may be a coop, but I was looking at the broken privacy fence. That's the only thing I can see.
Are you I mean,
there is some tree debris scattered.
I'm trying to figure it out too. So I see the grass.
Mm-hmm. Right.
But on the miscellaneous junk and debris. Actually, so this is the junkyard conditions. Okay, I see like a fence panel. I see a metal, I guess a garbage can of some kind.
It's a burn barrel.
A burn barrel, okay, it's a burn barrel. And then, but I don't see it. Okay, the fence panel's still there yesterday. Mr. Tron, did you take this photo?
Yes, sir.
Okay. I mean, what besides the fence is there?
That's the only issue.
Okay.
I was hoping for contact. It could have been easily resolved.
That the fence panel needs to be moved?
Yes, sir.
So in 20-31, it shall be unlawful for the owner or tenant of any land to permit, cause, or have thereon any accumulation of junk, debris, rubbish, and vegetative matter. It doesn't say any individual piece of junk, it says accumulation of junk. So the way I read that is there has to be more than one piece. I agree that the fence panel may be considered junk, but I don't see an accumulation of junk. I mean, unless there's some kind of, something I'm missing, I just...
One garbage bag, it could be just one, not accumulation of more than just one.
One garbage bag?
I mean, I'm just hypothetically speaking. If I have one garbage bag, it's just one. And then it accumulates, then it's 3 or 4, you know? So, I mean, that could be
But that's an after fact.
I know, but I mean, if it's not in use,
I guess I'm trying to understand your point. So,
I mean, just
one
because
garbage
you're saying
bag?
it's not a garbage bag there, but you're saying that it's not accumulation, being
Yeah.
that it's just one.
Correct.
A broken fence.
Right, because
But if it's
for example,
broken
if just one thing was a violation, I would think that 2031 would read, it shall be unlawful for the owner or tenant of any land to permit, cause, or have thereon any junk, debris, rubbish, but it says accumulation. And so to me, that word has meaning, and the meaning is that it's to be a violation of the code. It can't be as simple as having one thing in your yard that needs to be brought inside. It needs to be more than one thing.
Well, there is tree debris out there too, so I mean.
Okay, so let's accumulation of vegetative matter. So let's look at that. Vegetative matter. Mr. Charm, where's the tree debris? I mean, where's the vegetative matter here that would be a violation and something more than just the natural? It's a pile of tree debris? Okay. Mr. Dwyer, is there tree debris on the property? I mean, is this an accurate photo?
There is some that I've been trying to take care of, but I mean, we have oak trees, and we were told that because of where we live is we're not allowed to touch them.
Who is Lorna Dwyer?
My wife.
Okay, all right.
I mean, we wanted to just cut the trees down, but we were told because they are oak trees, we're not allowed to touch them. Unless we can prove that.
How did the tree debris get there? I mean, did you?
The storms.
Storms?
Yeah.
It knocked it out of the trees?
Yeah, part of, I mean.
You didn't,
no.
you didn't create a pile of
no.
this? This is just natural?
Yeah.
It just fell?
It's just getting knocked down from the. There was one little pile in front that we've got cleaned up now. With the rest of it, with the Spanish moss on it, that all came down from the trees.
Is this a residential lot?
Yes.
Okay. Is it vacant?
No.
Oh, okay. Does it, Mr. Sean, does it change your opinion at all that the testimony is that that vegetative matter just fell off the tree? It's not something that was put together? You think that if there's just a bunch of leaves that fall from the tree along with branches after a storm, that could be a code violation?
I think he could.
If you look at the definition of vegetative matter.
Yeah, I want to see. I was looking for it. I couldn't find it.
It's grass clippings, plant clippings, tree limbs, fallen trees, fallen fronds.
Okay.
Piles of leaves and other yard debris.
Where is it? I'm just trying.
It's in the definition section 20-3.
I'm there and I don't.
It's towards the end.
It's not here. I've only got vehicle.
Oh, I've got vegetative matter above vehicle.
I would love to. This was printed in 2014, so maybe.
Oh, that's probably here. Let me.
That was my issue. I just wanted to see that definition. Thank you. Aha. Ooh. Amended in 2018. There you go. Shall mean grass clippings, plant clippings, tree limbs, fallen trees, palm fronds, pile of leaves. Okay. It's a highly technical, unfortunate violation of the code, but I guess I'm going to find it. The virtue of it is that it won't take you long to fix. How much time do you need?
Probably just less than a month.
Less than an hour, I think.
Well, I'm a truck driver, so it's.
I gotcha. Well, you've already had to sit here for 3 hours.
Yeah,
so,
I know.
Okay, what's the county's recommendation?
Citrus County Code Compliance Division respectful requests a fine of $50 a day for both violations, along with administrative costs to begin the date after you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We would also ask Special Master additionally fine that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
How much time do you need to mow the property?
So the riding lawnmower just broke, so it's push mowing out. Probably a couple of weeks.
Okay. I mean, will 30 days suffice?
Oh, yeah.
All right. Then I'll find that the property.
I do have one other question is,
Yeah.
We have climbing vines on the fence.
Okay.
Is that considered overgrowth or?
It's not an issue in this case. It will not be a part of my finding a violation that there's a vine on the fence. That's not what I'm finding the violation to be. I'm finding the violation to be the growth in excess of 18 inches in height, and I think that's what the county's presented. Yeah. Okay, so in each case, the property is found in violation. In each case, property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This applies to each case. The fine would be recorded and would constitute a lien on the real or personal property of Mr. Dwyer. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law. Thank you.
Next case on the agenda, next two cases on the agenda, Judy Lynn Looting and Deanna J. Borman Sages. Where's the rest of it? Oh.
I don't see.
I'll do it. Judy Lynn Lundeen.
Oh.
Diana J. Sages Borman, Emil H. Borman, and Frederick J. Borman.
Oh, all right. Pages 24 and 25.
Still
Welcome.
morning, so
Yeah,
good
it
morning.
is so far.
Matt Hampton, Citrus County Code Compliance Officer. It's two cases. Case number 2164118, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Case number 2164144, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 6679 South Wald Point, Homosassa, Florida. Property owners Lundeen Judy Lynn, Sages Diana J. Borman, Borman Emil H., and Borman Frederick J. Good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection May 5th, 2022. Photos I took took for the corrective action inspection on July 21st, 2022. And photos I took during my final inspection August 16th, 2022. Exhibit B, a copy of the notice of violations, a copy of the notice of hearing, a picture of the notice of hearings posted at the property, and a copy of the posting affidavits I completed on August 4th, 2022 for both cases.
Okay. So it's exhibits A and B in each case?
Yes, sir.
All right. Okay, is there anyone from the public who's going to want to be heard on this case? Let the record reflect that there is no response. All right, thank you. Without objection, what's been proposed as exhibits A and B in each case are admitted.
I conducted my initial inspection May 5th, 2022, observed the property to be in violation of the ordinance listed above. For the junk case, there was household garbage, furniture, scrap metal, and other miscellaneous junk and debris around the property. For the vehicles, multiple vehicles either without tags or appeared inoperable. Notices of violations were issued May 12th, 2022. I conducted my corrective action inspection July 21st, 2022. There was a small amount of cleanup since no action, and there were vehicles that were removed from the property. Notice of hearings were issued for July 21st, 2022. I have not had any contact with anyone with regard to this property. I posted the property in the Lecanto Government Building August 4th, 2022. As of my final inspection August 16th, 2022, the property remains in violation for junk and vehicles.
I agree. I think that the photos speak for themselves. It doesn't look like there's been enough improvement. What is the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $100 per day per violation, along with the administrative cost to begin after the date you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they are advised of the violations, and this amount is appropriate given the severity of the violations and the respondent's actions relative to these violations. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violations have abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. Each property is in violation. In case number 2164144, the owners are granted 30 days from today to abate the violation. In case number 2164118, they are granted 60 days from today to abate the violation. In each case, if the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owners. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owners shall be responsible to pay all costs required by county law.
Thank you, sir.
Thanks.
Next case on the agenda, David A. Prusik, case number 2168642. Alan Jonason, code officer on the case, page 30 your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is a repeat violation initially observed on 5 February 2021. The address of the violation is 122 North Cedarview Terrace, Inverness, Florida. This is case number 216-8642, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Property owner is Perusek David A., has been previously found guilty of the same violation at the same address on 23 April 2021, which was case number 213-2811, with $20,637 in imposed fines. I have good service via posting on the property.
Did it ever abate?
It did not.
Okay.
I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, findings of facts from the previous case, 213-2811. Exhibit B, photos I took during my initial inspection on 25 July 2022, and photos I took during subsequent inspections on 9 August 2022, 11 August 2022, and my final inspection on 16 August 2022. Exhibit C, a copy of the notice of hearing sent to Perusek David A., a copy of my posting affidavit, and a photo of the notice of hearing posted on the property.
Have you ever had any contact with the owner?
I have. This was a Citrus County Sheriff's call that I went on, and the property owner met us each time that I've gone, so other than one time that I had to take photos.
What was the purpose of the sheriff's call?
Evidently, it is a flop house location. I have other cases against the property as well that will be heard next month. But it is a I'm trying to separate these.
Okay. Looks like this was a case that was in front of me.
Yes, sir.
And I wrote a very interesting clarification on the order. You testified that it's never been brought into compliance?
It didn't. No, sir.
But this is a case under the same code section.
Yes, sir. Yep, I made a mistake.
Okay. What was your mistake?
Just the affidavit of compliance. Is
That's
in
what
there.
yeah. Is that in here?
It is.
Okay.
It should be.
I do not see it. Maybe it's in the big packet. Here's what else you've given me. I just don't. Yeah.
It did abate though.
Okay. I mean, the owner's not prejudiced if I make that finding. I think, based on the testimony. Okay, so let me look. Do you need me to go get it? I think it would help me to understand when it abated. I'm not trying to make y'all's lives difficult. How long will it take, Ms. Spiros?
Less than 5 minutes.
Okay. Well, in that case, do you want to offer testimony, Mr. Jonathan?
Yes, sir. I conducted my initial inspection on 25 July 2022 and observed that the property was in violation of junkyard conditions. During my subsequent inspections on 9/11 and 16 August, I observed very little change to the property, and I have had contact with the property owner, but as of my final inspection on 16 August 2022, the property remains in violation. Again, this was a Citrus County Sheriff's Office call, and the property owner is an elderly gentleman who really does not understand the significance of what's happening on his property, is what it seems like to me. But he has made some progress, but not a lot of progress. If I can add additional data about other cases, I don't know if that's relevant or not. It may
I mean,
not
I'd
be.
like to know.
So I have another repeat violation of unlicensed vehicles that will be coming before you next month. And that one had abated as well, but it is a repeat. And then I have 2 additional cases on the property for unlicensed, unregistered vehicles and inoperable vehicles, as well as living in accessory structures.
How big is the property?
It's a little over 2 acres.
And you indicate that it's your belief the owner does not fully understand what's going on his property?
He evidently, this is just what I was told, that he was in an accident years ago, and that he suffers from memory loss, frequent memory loss. And so I don't know that he remembers or knows what is going on. But I've supplied him with copies of everything and shown him, along with the sheriff's department, what he needs to do to fix the violations.
Supposedly they've complied before. Do you
They-
want to take
they
a look
did.
at this, or thank you. This is an order acknowledging compliance in the exact same case number 2132811, where there was a prior violation. It's signed by me on September 1st, 2021. I vaguely remember both the respondent and the case. Well, what is the county asking for?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with the administrative cost, to begin on the date of the posting of the notice of hearing on the property, which was 4 August 2022, and continue until 16 August 2022, which would be 12 days at $150 per day, totaling $1,800. Also, a fine of $150 per day from this day forward until the violation is abated. We would also ask that the special master additionally find that it is the respondent's responsibility to notify the Code Compliance Division when the violation has been abated, in order to allow for reinspection.
I'll admit the order acknowledging compliance as Exhibit D. All other exhibits are admitted. I don't remember asking if there was anyone from the public who wishes to be heard. Is there? Let the record reflect there is no response. I will adopt the county's proposed findings of fact. The property is found in violation. From the time period of August 4th to August 16th, there shall be a fine of $150 per day, for a total fine assessed of $1,800. From today's date going forward, there will be a fine of $150 per day until the violation is abated. Yeah, the fine will be recorded and will constitute a lien on the property. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and Mr. Parasek shall be responsible to pay all costs required by county law.
Thank you.
Thanks.
Next case on the agenda, Wargo Investments, LLC, case number 2160673, Code Officer J.C. Charlton, page 35 of your agenda. J.C. Charlton, Citrus County Code Compliance Officer. This is case number 2160673. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address, 706 South Sickle Point, Inverness, Florida. Property owner, Wargo Investment, LLC. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during the initial inspection on March 17th, corrective action inspection on June 8th, follow-up inspection on August 2nd, and my final inspection on August 16th, all of 2022. Exhibit B, notice of violation, notice of hearing, a copy of the continuance letter, and photos of the posted property, and a copy of the posting affidavit I completed.
Is there anyone from the public who wishes to be heard on this? Let the record reflect that there is no response. Without objection, what's been proposed as Exhibits A and B are evidence.
Initial inspection was conducted on March 17th with Code Officer George Pearson. The pictures depict violation of junk and debris on the property. A corrective action inspection was conducted on June 8th, and the property remained in violation. I conducted a follow-up inspection on August 2nd and observed debris and broken household furniture on the property. As of my final inspection on August 16th of 2022, the property remains in violation.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests Special Master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondents' actions relative to this violation. We would also ask the Special Master additionally find that it's respondents' responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
Okay, the property is found to be in violation. The property owner is granted 30 days from today to abate the violation. I'm sorry, was it $50 a day that you recommended?
Yes.
Okay, if the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Wargo Investments, LLC. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation.
Thank you.
Yep.
Next 3 cases on the agenda. Robert A. Arnold, case numbers 216-6570, 216-6671, and 216-6672. Code Officer Amy Becker, pages 5, 6, and 7 of your agenda.
Amy Becker, Co-Compliance Officer. This is case number 2166570, excessive growth and accumulation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. Case number 2166672, abandoned, unserviceable, and unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. Case number 2166671, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address in all 3 cases is 89 South Scarborough Avenue, Lecanto, Florida. The property owner for all 3 cases is Roberta A. Arnold. I have good service on all 3 via posting of the property as well as the Lecanto government building. For all 3 cases, I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on June 16th, 2022. Photos taken on July 1st, 2022 at my corrective action inspection. Photos taken on July 29th showing the posting of the property. And photos taken on my final inspection on August 16th. Exhibit B, a copy of the notice of violations, a copy of the notice of hearings, and a copy of the posting affidavits.
So exhibits A and B in each of the 3 cases. Are they all different?
The pictures are all different.
Okay, all right. Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there's no response. right, exhibits A and B are admitted in each case. Thank you.
Yes. I conducted my initial inspection on June 16th and observed excessive growth and accumulation in excess of 18 inches of the property. I also observed a vessel with an expired tag. I also observed junkyard conditions as far as discarded furniture, appliance.
On the unlicensed and operable vehicle case, I see 3 different vehicles that are in the photos. One is the boat, then there's a truck that appears to have a license plate, and I don't see the expiration. I don't know anything about that. I don't know if that's a violation or not. What are the violations in that case?
Right. I was allowed access to the neighbor's property, so now I could view, because I couldn't see the gray one that was untagged before. So the gray one's untagged, and then the pickup, the tag's expired.
Okay.
That was in 2009, it's expired. So we've got an expired tag on the pickup. We've got the boat tag that expired 2012, and then we have the untagged gray vehicle.
All right, and then in the junkyard conditions case, I see it may be debris on the porch.
The junkyard condition, if you look at the 816, you'll see there's discarded furniture that's been outside under that carport. You can see a small table, and then you can see the rest of it. It's almost, I think it's bedroom furniture. But you also see an appliance in the back of the pickup.
Mm-hmm. Are the storage containers considered junk?
You mean the gray?
There's several stacked storage containers that are. Do you know what I'm talking about, or do you need to see it? Yeah. On page 9 of 10, Exhibit A.
No, but I would
Okay.
consider that
Right.
because they've been out in the weather
Right.
for years. According to the neighbor,
Yeah, that's what it looks like. Right. What's the county's recommendation?
the county's recommendation on case 2166672, case 2166671, and 2166570, the Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day per case, along with administrative costs to begin after the date you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated, when the violations have been abated, in order to allow for reinspection.
And I'm sorry, what was the amount again?
50 per
I don't know
case.
why I keep
50
missing that.
per
Thank
case.
you.
No
Okay.
problem.
I adopt the county's proposed findings of fact. The property is found in violation in each of the 3 cases. Do you know how big the piece of property is?
No.
I mean, do you have an approximation, whether it's half an acre or an acre?
I'm pretty sure it's half an acre.
Okay.
And I can't find the owner. I mean, I haven't found
That's
a death
what I'm worried
certificate.
about, yeah.
I haven't found the death certificate. The neighbors came over and talked to me and said people have been driving by looking at it, but I literally cannot find the owner anywhere. Not the
Right.
tax records, all the addresses come back to
Right.
this address.
Yeah, it appears based on the facts regarding the vehicles, regarding all this other stuff, that it's possible the owner hasn't been around for a long time. I don't know. So, nonetheless, I will grant, let's see, in the grass case, 30 days from today to abate the violation. That's case number 2166570. I say the grass, the overgrown undergrowth, etc. Case number 216-6672, the unlicensed, unserviceable, inoperable vehicles, 60 days to abate the violation. In the junk case, case number 216-6671, also 60 days from today to abate the violation. In each of the three cases, if the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Roberta Arnold. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law.
Next case, Julia C. Fitzpatrick, case number 215-9705, Code Officer J.C. Charlton, page 14 of your agenda.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 215-9705, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 819 Sherwood Ave, Inverness, Florida. Property owner Julie C. Fitzpatrick. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during the initial inspection on March 1st, corrective action inspection on June 2nd, the follow-up inspection on July 29th, and my final inspection on August 16th of 2022. Exhibit B, the notice of violation, notice of hearing, copy of the continuance letter, photos of the posted property, and a copy of the posting affidavit I completed.
Is there anyone from the public who wishes to be heard? There is no response. Exhibits A and B are evidence.
Code Officer George Pearson conducted an inspection on March 1st, 2022, and the photos depict violations of junk and debris. A violation of junk and debris. A corrective action inspection was conducted on June 2nd, and the property remained in violation. I conducted a follow-up inspection on July 29th and observed tree debris and appliance in the backyard and garbage in the backyard. As of my final inspection, the property remains in violation with household garbage piled up in the backyard, and the appliance and tree debris also remains on the property.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests a special master assess a fine of $100 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given to the severity of the violation and respondent's actions relative to this violation. We would also ask the special master additionally fine that it is the respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. The fine will be recorded and constitute a lien on the real or personal property of the owner. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law.
Thank you. Next two cases on the agenda, Jeff Harrington, case number 216-2931 and 216-2932, Code Officer Jillian Nocella, pages 17 and 18 on your agenda.
Jillian Nocella, Citrus County Code Compliance Officer. This is for case numbers 216-2931, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of Citrus County Code of Ordinances, and case number 216-2932, unlicensed or inoperable vehicles, violation of Chapter 20, Article 4, Section 20-41, Citrus County Code of Ordinances. The address is 12615 East Trails End Road, Floral City, Florida, 34436. Property owner is Jeff Harrington. I have good service via posting at the property and at the Lecanto Government Building. I would like the following documents, request that they be authenticated and admitted into evidence. Exhibit A, photos taken during the initial inspections on April 21st, 2022, and photos from subsequent inspections on May 17th, 2022, and July 21st, 2022, and photos taken at my final inspection yesterday, August 16th, 2022. Exhibit B, the notices of violation and the notice of hearing, photos of the posted property, and copies of the posting affidavits.
Are the exhibits identical or different for each?
They focus on different pictures, but
sure.
Same photos, same dates.
Gotcha.
And the same documents.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response. Thank you. All right, exhibits A and B in each case are admitted.
On April 21st, 2022, an initial inspection was conducted. There was an unlicensed vehicle as well as appliances, scrap wood, tires, and other miscellaneous junk and debris on the property, which are both violations of the county ordinances mentioned above. No changes had been made regarding the conditions of the property during the subsequent inspections. And as of my final inspection yesterday, August 16th, 2022, the property is still in violation.
You decided to let them go on the overgrown, unkempt grass?
These were cases I inherited from a previous code officer, so I just continued for right now with the ones
I'm
that
not
were
begging you to bring
started.
it. I was just,
Yeah.
let's see. Okay. What is the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per violation, along with the administrative cost to begin after the date you deem sufficient to abate the violations. This amount was selected based on the actions of the property owner once they were advised of the violations. We would also ask the special master additionally find that it's the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found to be in violation in each case. In case number 2162932, the owner is granted 30 days from today to abate the violation. In case number 2162931, the owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, in either case, or this applies to each case, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Mr. Harrington. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county ordinance or regulation.
Thank you.
Thanks.
Next case on the agenda, Carl Sr. and Gloria Hagstrom, case number 2168513. Code Officer Alan Jonason assigned to the case, page 16 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2168513, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. This is a repeat violation, initially observed on 27 July 2020. The address is 2710 East Jupiter Street, Inverness, Florida. The property owners are Hagstrom Carl Sr. and Hagstrom Gloria, have been previously found guilty of the same violation at the same location on 16 September 2020, which was case number 280584, with no imposed fines due to the property coming into compliance the same day, 16 September 2022.
Wait, you mean 2020?
2020.
Okay.
My apologies. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, findings of facts from the previous case, 80584, and an affidavit of compliance from 16 September 2020. Exhibit B, photos I took during my initial inspection on 21 July 2022, photos I took during my subsequent inspections on 11 August 2022, and final inspection on 16 August 2022. Exhibit C, a copy of the notice of hearing sent to Hagstrom Carl Sr. and Hagstrom Gloria, and a signed copy of the certified mail receipt.
Is there anyone from the public who wishes to be heard on this case? I'll let the record reflect there is no response. Without objection, what's been proposed as Exhibits A, B, and C are evidence.
I conducted my initial inspection on 21 July 2022 and observed the property was in violation of lawn. During subsequent inspections on 10, 11, and 15 August, I observed no change to the property. And I have had contact with the property owner. She lives in Connecticut, and she's had some health issues. She's an elderly lady, and she's trying to find a lawn service. She had a lawn service, but she said evidently they haven't been cutting the grass. She was unaware. And she said that she would have it cut as soon as she could, is what she told me.
When did you have contact?
Monday.
Okay.
Monday. As of my final inspection on 16 August 2022, the property remains in violation.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin on the date of the signed certified mail receipt, which was 28 July 2022, and continue until 16 August 2022. That'd be 20 days at $50 per day, totaling $1,000. Also, a fine of $100 per day from this day forward until the violation is abated. We would also ask that the special master find that it is the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection.
That looks like 19 days to me, not 20 days. I mean, I'm not, 28 July, so 28, oh, is it 28, 29, 30, 31? Okay, so
Yes,
20
sir.
days, all right. All right, I'll adopt the county's proposed findings of fact. The property is in violation, and there will be a fine assessed because this is a repeat violation. The fine that will be assessed is $50 a day, running for the time period of July 28th through August 16th. That's a total period of 20 days for a total fine of $1,000. Further, there will be a fine assessed for each day that the property remains in violation from today's date forward of $100 per day. The County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. This fine itself will be recorded and will constitute a lien on the real or personal property of the Hagstroms, and the property owner shall be responsible to pay all costs required by county ordinance or regulation.
Thank you.
Thank you.
Next case, Janet Lawler et al., case number 2164665, Code Officer Alan Jonason, page 21 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2164665. Excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. The address is 3363 East Buffalo Lane, Hernando, Florida. Property owner is Lawler Janet et al. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 16 May 2022. Photographs from a compliance inspection on 8 July 2022. And photos of my final inspection conducted on 16 August 2022. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, and a copy of the signed certified mail receipt.
Is there anyone from the public who wishes to be heard on this case? let the record reflect that there is no response. Without objection, what's been proposed as Exhibits A and B are evidence.
On 16 May 2022, I conducted my initial inspection and observed the property was overgrown. A measuring stick was used as a reference to show that the grass or weeds exceeded 18 inches, which is a clear violation of the ordinance listed above. On 16 May 2022, a notice of violation was issued for excessive growth and accumulation of vegetation. On 8 July 2022, I conducted a compliance inspection and observed no change to the property. I have had contact with the property owner, but as of my final inspection on 16 August 2022, the property remains in violation.
What did the property owner say?
So he indicated to me that he was having trouble finding a lawn service to take it on because there's a lot of overgrowth of vines and there's tree debris in the yard and things like that. He said that he thought could take care of it in the next couple weeks, that he did find somebody finally. But that's it. And I've talked to him probably 5 or 6 times.
All right. 5 or 6 times?
Absolutely. He's keeping me updated about him trying to he said he found somebody, and then I guess it fell through, and he would just call me and update me on these things.
All right, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost, to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I'll adopt the county's proposed findings of fact. The property is in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Janet Lawler et al., that is to say the other owners as well. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owners shall be responsible to pay all costs required by county ordinance or regulation.
Thank you.
Thank you.
Next case is on the agenda, Eleanor O. Levy, and case numbers 216-77. Wow, I cannot see. 216-7751 and 216-7767, pages 22 and 23 of your agenda.
Case number 216-7767, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. Case 216-7751, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address for both cases is 5216 West Corral Place, Beverly Hills, Florida. The property owner is Eleanor O. Levy. I have good service via posting of the property as well as the Lecanto Government Complex for both cases. I would like to authenticate the following documents and request that they be admitted into evidence for both cases. Exhibit A, photos taken during my initial inspection on July 6, 2022. Photos taken on July 27, 2022 at my corrective action inspection. Photos taken on August 3, 2022 showing the posting of the property. And photos taken on my final inspection on August 16th. Exhibit B, for both cases, a copy of the notice of violation, a copy of the notice of hearings, and a copy of the posting affidavits.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response. I once used that South Park joke in an appellate hearing, an oral argument, and the judge really did not like it, and really didn't like it, and started berating me for it, and asked me if I felt like Kenny. And I said, well, it depends on the order you give, Judge. So. Without objection, what's been proposed as Exhibits A and B in each case are admitted.
On July 6th, I conducted my initial inspection for accumulation of junk and debris and excessive growth and accumulation of vegetation. I found the grass in certain areas above 18 inches of the property, which is a clear violation of the excessive growth. And I found junkyard conditions as far as discarded furniture and household garbage in a pile in the yard. As of my final inspection on August 16th, the property remains in violation for both the grass and the junk.
Any contact with the owner?
The owner is deceased.
Oh.
The son is Mark Levy, who's living in the home. He's aware of the violation. As a matter of fact, he was bringing out a pile of trash to put, another bag of trash to put on the pile when I was there. So.
I mean, did he indicate any willingness to try and fix it, or?
He said that he doesn't have a phone, he doesn't have a car, he's in financial straits, and I said, well, it still needs to be fixed, and he said he'd make some phone calls.
Okay. What's the county's recommendation?
On both cases, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per case, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated, when the violations have abated, in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation in each case. In each case, I'll grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. The fine will be recorded and will constitute a lien on the real or personal property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record, and the property owner shall be responsible to pay all costs required by county law.
Thank you.
Last case on the agenda, Patricia Ann Newberry, case number 216-4018, Officer Julian Nocella, signed to the case, page 27 of your agenda.
Jillian Nocella, Citrus County Code Compliance Officer. This is case number 216-4018, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 8260 East Gobbler Court in Floral City, Florida, 34436. Property owner is Patricia Ann Newberry. Good service via posting at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A is photos taken during an initial inspection on May 5th, 2022, photos taken during subsequent inspections on June 7th, 2022, and July 22nd, 2022, and photos taken at my final inspection on August 16th, 2022. Exhibit B is a copy of the notice of violation and a copy of the notice of hearing, and photos of the posted property and a copy of the posting affidavit I completed.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response.
Sir?
Thank you.
On May 5th, 2022, an inspection was conducted and there were bags of household garbage and other miscellaneous junk and debris in the yard, which is a violation of the county ordinance mentioned above. The same conditions existed at the subsequent inspections on June 7th, 2022 and July 22nd, 2022. As of my final inspection yesterday, August 16th, 2022, the property remains in violation.
Why are they just leaving it out in garbage bags at the corner?
No idea.
Okay. I mean, I assume that, is there public pickup there, or is it private pickup?
For our county, everyone has to pay for their own trash service.
Right, okay, that's
So
what I was wondering.
I'm assuming they either think they have it and it's not being picked up, or they don't and they think maybe someone
Well,
will
that makes
just
sense.
pick it up.
What I was going to ask is if there was a public service, if they actually pick up trash that's just bagged and
Yeah,
not in a receptacle
no.
or something like that. So, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation. Property owner is granted 30 days from today to abate the violation. If the violation is not brought in compliance as ordered, did you recommend 50
Yes, sir.
a day? A penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owner. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
Okay, so that concludes the hearing. The time is 12:43.